Good morning, my lady.
Who is assisting me? Is it Mpo or is it Lisa? I just want to make sure that I've got a registrar to call the matter. I know that there have been difficulties at the tribunal because the infrastructure has not been working properly, but because the system was down. So I just need to establish that they are able to log in because they also need to keep the record. But we will also go through some protocols with you shortly. So give me a moment.
Thank you, my lady.
Thank you, my lady.
everybody. Apologies for that delayed start. We have finally located someone who's coming in to call the matter for us so that we can start. Mpho, are you in?
I'm in, Judge. Good morning. As it pleases the court, my lady, this is a matter between the Special Investigating Unit and Mr. Petrus Shaka Mazibuko plus 7 others, case number GP10 of 2021, appearing in the Special Tribunal of South Africa before Madam Judge Suwendu, 16 September 2021. My lady?
Yes, thank you, Mpho.
Thank you, Judge.
Just to make sure that we do the housekeeping, the proceedings are being recorded by the Special Tribunal, and I would request that parties who are not directly involved in making representation should please mute their cameras and mute their microphones so that we don't get background noise as we are now, because that interferes with the recording. And if counsel or attorneys are sitting together and both laptops are on, only one microphone can be on, because otherwise you will get feedback, as I'm getting it now, and that also interferes with the recording. All right, so I require that be please observed. Only those parties who are addressing the tribunal may have their video cameras on or microphone on. So thank you. Can we note appearances?
Thank you, my lady. It's Advocate Flat together with my learned colleague Mudau for the applicant, my lady.
As a court, please, my lady, Advocate M. Mpaka SC, together with my colleague, Mr. Mashaba, for the first to the third respondents.
Good morning, my lady. For the
Give me
fifth.
a moment. Just give me a moment, please. Just give me a moment.
Okay, sure.
Can I just make sure that I get the spelling of the counsel who appears for the first to third respondent correctly, please?
Oh, Mpaka,
Your name for the record, please.
Mpaka, Mphaga, and my junior is Manala, Manala.
Thank you. And appearances for the fourth to sixth respondent?
As may please the court, my lady, it's Advocate RPA Ramawele SC for the fourth, fifth, and sixth respondents.
Are you on your own?
I'm on my own, unfortunately.
Right. Just want to also note there has been no opposition by the seventh respondent.
That is correct, my lady.
Right. All right. Over to you, Ms. Platt.
My lady, I note that they have an issue with jurisdiction, the first to third respondent. So I don't know if my lady would want to hear that first.
Yes.
Or not.
Yes. I think it is correct that I would want to hear that first. And I thought that you might want both of, at least you, to lay the context of the application before we dive into the jurisdictional points that have been raised.
Okay, my lady, I can do that indeed. My lady, this is an application in which it's the part B. The part A was the ex parte urgent application in which we got a preservation order. Part B is to deal with the forfeiture of that preservation order, as well as to seek declaratory relief. So it is merely a declarator for finding that the respondents contravened Section 3 and Section 17 of the Prevention and Combating of Corrupt Activities Act, as well as Section 4 of the Prevention of Organized Crime Act. So we're coming on that basis. We seek that relief, my lady. And that is why we are here today.
Yes. I also noticed from the papers that when you applied for the preservation order, subsequent to the granting of that order, you also sought certain amendments.
Yes. Those amendments were not opposed, my lady, so those amendments have gone through. So the amendments that we have sought were not opposed by any of the parties, and those amendments have now been effected, and we have filed the amended pages.
Yes. I think that context is important.
Yes. Thank you, my lady.
Okay. I also do notice, Ms. Platt, that actually the feedback, it's coming from your microphone. So when you are muted, there is no sound, but when your microphone is on, there are these difficulties. So I ask you to please sort that out whilst
Okay.
yeah.
Okay, I'll see how I can do that.
Yes.
Okay, thank you.
Thank you. All right. So we obviously want to hear from the respondent who is raising these preliminary jurisdictional issues, and we want to explore if there is merit to the jurisdictional points that have been raised. So over to you.
Thank you, my lady. On behalf of the first,
I see that my senior is off the chat. I just don't know if you can just quickly check with her. It's just right across.
Is he going to be addressing me on this?
No, I wanted to make sure that you are aware that she just went out. I don't know what happened.
I see. I think it's because she is sorting out the...
No, my lady, I'm still here. I'm still here.
Okay. Now, if you are also wanting to bring anything to my attention, can I please recommend that you use the raise hand facility on Teams so that we don't interrupt the flow of the address and people don't just jump in as and when. So I will keep an eye whenever a party needs to address me in the middle of an address. Please use the raise hand facility. Thank you.
as a copy, my lady, on behalf of the first to the third respondents, we have raised the quoting limine in respect of legal standing and jurisdiction of this court to hear this matter. And my lady, your ladyship will note that the notice of motion which has been amended, the pillars of the orders that are sought in that notice of motion as amended are based on the Prevention and Combating of Corrupt Activities Act 12 of 2004, and the Prevention of Organized Crime Act 121 of 1998. Those are the pillars of the orders that are sought by the applicant in this matter. We deal with the issue of jurisdiction on page 17, 05417 of our heads. And the first issue we mentioned, I don't know, maybe has got to the page number.
Let me just clarify something that occurred to me when I was reading the papers. Are you saying that on the affidavits, the jurisdictional point is being raised by the first to third respondent?
As a court, please, yes.
Oh, all right. I seem to have thought it was the other way around.
Yeah.
All right. Yes. Okay, continue.
My lady, we first raised the issue in respect of the fact that the applicant's case is beyond the scope of the enabling proclamation. The second point is that the applicant's case is beyond the framework of the Enabling Act. And thirdly, the relief claimed lacks precedence or any condition of law in law.
Right.
But the proclamation R11 of 2008, dated 6 April 2018, that you find on P00140 of the papers, we submit that the objective of that proclamation is the recovery of losses that may have been suffered by Eskom. It also deals with Transnet, but we can accept, but it was earmarked for those two SOEs in respect of the procurement processes that were followed in those SOEs. Now we mentioned with respect the judgment in Special Investigating Unit versus Naderson, 2002 Volume 1 SA 605 SCA at Para 5, where the SCA, when it interpreted the proclamation of the SIU, it stated that a unit such as the appellant is similar to a commission of inquiry. It is as well to be reminded in the ways of Corbett J.A. in Esvis Nordier, 1975, Volume 1, of the invasive nature of commissions, how they can easily make important inroads upon basic rights of individuals. But we have highlighted one point in the passage that we quote, that a tribunal under the Act, like a commission, has to stay within the boundaries set by the Act and its founding proclamation. It has no inherent jurisdiction, and since it trespasses on the field of the ordinary courts of the land, its jurisdiction should be interpreted strictly, meaning that the jurisdiction of the court in respect of this POCA and this Prevention of Combat of Corrupt Activities Act must find its source somewhere in the SIU Act. And
no, just hold on. So let's not conflate the 2 points that you raise. First, let's deal with your issues around the proclamation, because I do want to explore the second point, which is, and I don't want us to conflate the two. I need to understand carefully from you in what respect does the investigation and the findings by the SIU and the subsequent application and now Part B colors outside of the borders of the proclamation? I want to understand that.
The issue here, my lady, is the issue of loss. Because you are saying that the objective was in respect of recovering the loss that was suffered by Eskom in respect of procurement relating to the logistics. In respect of this matter, we deal with the tracking and so on. So, my lady, we are saying that if one looks at the facts of this case and the conduct that is alleged to have been committed by the first respondent, there is no causal connection in any way, and there is nowhere in the papers where we are told that ESCOM, as a result of this contract, they suffered any losses. Nowhere. And therefore, the whole recovery of losses does not arise because in this application, as your ladyship will note, it is the fact that there was a contract that was granted to the fourth respondent, and that contract, as we speak, we are not even told that contract has been subjected to any review, that there are any steps to set aside that contract. That contract is still intact. Nowhere in the papers we are even being informed that there were any irregularities or evidence of any irregularity within that contract. All we are hearing, my lady, it is simply hearsay, some kind of evidence to say that there may be a suspicion that the first respondent could have assisted the fourth respondent in acquiring the deed, but there is no evidence to that effect. And my lady, as we have indicated in our papers, we have tried in our heads to show your lady the process in respect of procurement at ESCOM, wherein the first respondent plays no role at all. And it is not the case of the applicant that the first respondent has any role to play in respect of the position he holds at ESCOM. Therefore, my lady, the issue of firstly whether the contract was procured unlawfully does not arise. So we submit, my lady, that the purpose of this proclamation was to make sure that where there was maladministration in respect of procurement processes, where it can be established as well as any illegality, then in that case, my lady, whatever proceeds would have been derived from that contract, then they are recoverable. But here we don't have any evidence at all that that what happened. Your ladyship has not been provided, for instance, with bid documents to indicate whether there could have been a role to influence this contract. Your ladyship has not been provided with evidence from all the committees, the bid adjudication committee, up until the board. It is the board of ESCOM that awards such contracts. No way, my lady, where one could have even inferred the possibility of the first respondent having been able to influence the contract. There's not such evidence. So solely the applicant is simply relying on POCA and the PCCA Acts to try and say to this court that it has jurisdiction. So our submission in respect of the proclamation, we say that its objectives clearly was trying to recover monies which could have been lost by ESCOM, but there is no proof of any loss at all in these papers. So we submit that on that basis, my lady, that this whole process is beyond the scope of the proclamation. And my lady, we also...
Just before you move on, where do you find in the wording of this proclamation this limited view of what was intended? Let's go back to the wording of the proclamation itself.
Yeah.
Because I need to be able to interpret what you've just told me against the actual wording and the actual scope of the proclamation. So where is this limitation?
My lady, it is, when you read on page 00140.
Just hold on, 00140
of the papers.
Is it
00140.
I beg your pardon?
001/40.
Right.
But in paragraph 2 thereof, it says, and whereas the institutions of or the state has suffered losses that may be recovered. And whereas I deem that the said allegations should be investigated and civil proceedings emanating from such investigation should be adjudicated upon. And my lord, that at the foot also of the page there, it says there, and to exercise or perform all the functions and powers assigned to or conferred upon the said Special Investigating Unit by the Act, including the recovery of any losses suffered by the institution or the state in relation to the said matters in the schedule. So we say that that, in our view, simply says that the objective was to make sure that there is an investigation, and if any malfeasance or any corrupt activities are found, therefore the losses are recoverable. But in this instance, we are saying that it is not possible because no losses have been established in respect of this contract in particular. And we submit, therefore, that the whole purpose was to make sure that either through civil proceedings, because that's when we say that the tribunal has been granted jurisdiction for civil proceedings to recover monies on behalf of the state. And in this instance, we submit, my lady, that it does not arise because no monies of the state have been lost or were to be lost by the applicant. Yes. And my lady, just to jump to the other point in respect of the issues of criminality, because I read what the applicant seeks to do. Basically, when I read the amended notice of motion, it reads like a charge sheet in a criminal court, because it requires our lady to make a finding of crime against the applicants based on the papers on its own. And we submit, my lady, that that aspect should have been left to the proper court, being the High Court and the National Prosecution Authority, my lady, in terms of POCA and in terms of the PCCA. My lady, those two acts, you can read those two acts, my lady, nowhere do they mention the SIU. Nowhere. My lady, those two acts, they are limited to the National Director of Public Prosecutions and to the High Court. At least if one reads the Prevention and Combating of Corrupt Activities Act, it recognizes your ladyship only in respect of when it defines who the court is or the judge is. That's the only case. But in the Act, it provides a process on how matters that are related to the two acts should be proceeded with in terms of forfeiture. It grants the National Director of Public Prosecution the sole authority to bring application in respect of forfeiture and not the SIU. My lady, we are saying that if strict interpretation in respect of the SIU Act is what the court said in the SCA, it means that therefore there is simply no power at all. Once you invoke POCA and the PCCA, then this matter must be referred to the NPA. And even the Section 4, Section 2 of the SIU Act is clear on that point. It says that a special investigation unit must, my lady, it is couched in peremptory terms, must, as soon as practicable, after it has obtained the evidence referred to in Section 1D, inform the relevant prosecuting authority thereof, whereupon such evidence must be dealt with in the manner which best serves the interest of the public. Now, if you read my learned colleague's application or founding affidavit, they are saying that no, they were waiting for the conclusion of the investigation. But it is not what Section 4.2 says. As soon as it is practicable.
Let's do that. Let's look at Section 4 together. Okay. Because I want to make sure that I follow your argument. Let's look at it together.
Section 41D.
No, we have to look at the full section in context.
Yes.
And not extract just parts of the section. Have you got it?
Really, I'm just gonna get it from my junior here. I have it, my lady.
You have it, all right. But my understanding, and please correct me if I'm reading it incorrectly or point out where you and I differ on the interpretation, is first of all, the SIU is given these wide powers to investigate any allegations and to collect evidence. You agree?
Yes.
All right. So 41C in particular, the SIU is given the powers to institute and conduct civil proceedings in a special tribunal or any court of law. You agree?
Yes.
Now, in relation to what you see Roman numerals 1A, Roman numeral 1, 2, and 3. Have you got that?
Yes.
My reading of that is that it is couched in such wide terms that the SIU may seek any relief irrelevant to the investigation, any, and this is repeated right through, that the any means the special tribunal can come before, the SIU can come before the special tribunal and seek exactly this relief that it has following the investigation. So what do you say to my reading of those provisions?
Lady, but if you read D,
yes,
then it seems to limit the any, the generality.
Okay, so where is the limitation coming from your reading?
Meaning that once you are investigating and then you find evidence that points to criminality,
yes,
then you refer them to the relevant prosecuting authority. Mm-hmm. And the fact that it says as soon as it is practicable in terms of 4.2, meaning that it doesn't have to finish the investigation, but refer them to the National Prosecution Authority. Why it is so? It is because POCA Act and the PCCA Act, they cloth the power to bring any application in respect of forfeiture to the High Court by ex parte application and so on. Therefore, that part of the criminality is the one that we have to refer, and they then have to invoke those provisions to oppose the courts.
All right, so what happens then, if I hear you correctly? What happens in instances where there is no criminality, but there is unlawfulness and there is a public wrong perpetrated? What should happen there?
My lady, if it is related to the issues that are to be investigated in terms of the proclamation, then those matters can be dealt with by the court. But in this instance, the applicant has chosen to solely rely on POCA and on PCCA. And that in itself, basically what he's saying to your ladyship is that there is an act of criminality. And that's where our issues are.
Why do you say that? I looked carefully at both the two pieces of legislation. Why do you say that they are limited to criminality? What about unlawful conduct that falls short of a crime? I understood from my reading that unlawful conduct, which may not be criminal, also falls within the purview of this application. So help me by referring me to the provisions that you rely on.
Lady, the provisions I'm relying on strictly are based on, as I indicated to your ladyship, to Section 4.2 of the SIU Act. There's a purpose why Section 4.2 is there. It is because it says.
Are you solely relying on 4.2, or are you also referring to the actual legislation? Because I want us to look at all of these pieces together so that I understand you.
I'm also relying on the actual legislation.
All right, which piece of legislation do you want us to start with?
The Prevention and Combating of Corrupt Activities Act 12 of 2004.
All right, let me go to the authorities. Just give me a moment. All right, so we start with the Prevention and Combating of Corrupt Activities Act, you say?
Yes.
And you say Section 4 does what?
No. Section 22 of that act. The topic is investigation regarding property related to corrupt activities.
All right.
And that section then clothes the national director as the person who must initiate a process in respect of the investigation or forfeiture of assets. And we are saying, my lady, that if there was any inkling from the Act to have clothed the SIU with any powers to bring application that relates to issues of corrupt activities, then it should have said so. But in this Act, it clothes the national director as the person who must initiate. That's why we are saying, therefore, that in terms of Section 4.2 of the SIU Act, it says that as soon as it is practicable, the SIU must refer this evidence to the national director for investigations. And your ladyship would have been able to also see how the courts, especially in matters of the public protector, they've gone at length to try to restrict the functions of the public protector in respect to matters that are prescribed in that act, and not to go beyond. And but it is that purpose that we are saying that, for instance, if one looks at the SIU Act and the rules, they don't provide and articulate a process in respect of the forfeiture and applications as much as the Poker Act and the PCCA Act does. They don't. They're very limited, my lady. Only Rule 26 tells us that the court can give an order for a final forfeiture. There is no process. But I'm saying what has happened in this matter when the applicants amended the minutes of motion, they limited themselves only to poker and to the Prevention of and Combating of Corrupt Activities Act only. And therefore, they have arrogated upon themselves the power to investigate these criminal activities. They are saying in their order that they seek, your ladyship must declare that a crime has been committed. That is what they are saying in their prayers. And that's where the issue is. Your ladyship has said, yes, if it is related to other unlawful activities, then the SIU tribunal's jurisdiction can be invoked. But in these instances where they limit themselves to criminal activity, they must refer it to the NPA. My lady, those are our submissions, and we submit, therefore, my lady, that as a result of that, the proper forum to deal with this matter, it is the National Directorate Prosecutions with the other courts and not the tribunal. And we submit, my lady, that especially in this instance where we submit that there is no causal connection between any loss that has been proved in this matter. And we submit that in these instances, the SIU, once the whistleblower, as they allege, indicated that there may be some corrupt activities, immediately they could have taken this matter to the NPA, and the NPA could have acted in the same manner as the SIU acted, but to the right forum, which will provide and prescribe the right processes in respect of how this matter must be dealt with. And Malady, we have referred on paragraph 34 of our heads on page 054/22. Also, we have made reference to the judgment of Public Protector and others versus President of South Africa and others 2021, where the court also...
I don't think it's necessary for you to take me through the authorities because I would have looked at them. But my curiosity was more around the structure of the legislation and the limitations that you argue, all right, in the legislation. Now, I understood also that there was an employment issue that was being raised. Is that also part of the bouquet of issues you have?
In terms of?
Are you going to address me on this, or is someone else addressing you on this point?
Oh, Malady, yeah,
yes.
We are just mentioning, Malady, that the issue that the labor relations point that we have used to say that in respect of what they allege that there was no conflict of interest or failure to disclose, those are matters that the SIU refers to the SOE for disciplinary processes to ensue arising from it. Malady, you cannot use that to then say that there has been a contravention of POCA and a contravention of the FCCA Act. And we submit, Malady, that those are the issues that must be assigned to the employer as a recommendation that the SIU has found that in this matter, there has been a misconduct committed, and it refers it to the relevant employer to, as they have done, Malady, to proceed with the disciplinary process. So we submit, Malady, that it is not a matter that can really be subjected to this court to adjudicate upon.
And still, you also still rely on Section 4, again, to this point?
We rely on Section 4, Malady, in relation to these issues, and also on the proclamation itself, as we've indicated before, that there is no causality between the conduct of the first respondent and the losses that are alleged to have been lost, Malady.
Is there anything else you want to raise?
I referred to the authorities, as you said, that we have been able to note them, and in the POCA Act itself, also, I submit nowhere is the SIU mentioned to be a body that will be able to advance or all non-compliances in respect of POCA. We submit, therefore, that in that respect, the NPA was the authority that was well placed to have dealt with this matter. As a court, please.
Ms. Pat?
As the court pleases, my lady, I hope my sound is better and there's no feedback. Okay. My lady, let me address you on...
By waving like that, I mean, yeah, when you are quiet and when I'm not sure where your microphone is, whether it's on your computer or you've got... Yeah.
No, it's on my computer.
Something happens, but let's jog along. Let's make do.
Sorry, my lady, it is my computer. I had taken it off a speaker, so now it's just playing off my computer. My lady, can I first deal with this matter and go to the proclamation itself? 00140, page on case lines, my lady. 00140. And that's the proclamation, my lady.
Yes.
And the first to third respondents would have you believe that there must be allegations and there must be losses suffered, and those allegations must be investigated. Now, there need not be losses suffered. There can merely be improper conduct with no losses suffered, and therefore it will still fall under the proclamation. There's nothing that says it has to have all of these together. And the reason why I say that is because when you look further, it says, now therefore I hereby under section 2.1 of the Act refer the matters mentioned in the schedule in respect of institutions for investigation. And if you look below, you'll have A to G. Now I have checked that A to G mirrors section 2.1 of the Act. But if you look at improper conduct can merely mean an official has turned a blind eye, has not alerted anything, and the contract goes through and it happens lawfully on the part of the contract going through. That may happen. There may be no losses suffered, but it's that improper conduct that is unlawful. And it doesn't necessarily follow that there will be losses suffered. It says, including if losses are suffered, please recover them. It doesn't say it has to have losses suffered, otherwise you cannot investigate at all. And that cannot be the purpose of this Act, because harm to the public may not necessarily mean there was a loss suffered. Harm to the public is definitely one of the allegations that we can investigate, but that doesn't necessarily relate to a loss.
So let me just make sure I understand you.
Yes.
So improper conduct is wide enough to include unlawful conduct, unethical conduct,
yes,
and all of those, from what I understand, is that those are public wrongs,
yes,
which are envisaged,
yes,
which are intended to be addressed.
That is correct, my lady.
Yes. Okay.
So they harp on the fact that we're coming here seeking criminal relief. We are not coming under any criminality. We are not coming under any labor. We're not coming under any loss. We are merely saying we have found improper conduct and we want this court to declare that conduct improper. The NPA and ESCOM will take over the labor matter. The ESCOM will take over the labor matter. The NPA will deal with the criminality. We are not suggesting that that is what our role is. No, far from it. Hence, you will not see anything here where you will be finding somebody guilty of any crime, nothing like that. We are merely saying there was improper conduct. This court has the power in civil proceedings to deal with improper conduct and find such improper conduct. Then they say, well, PRECA, which is your prevention, I keep on getting that act confused with the POCA one, Prevention and Combating of Corrupt Activities Act, is specifically mentioned in the proclamation. If you go to F, it says, offense referred to in parts 1 to 4, or section 17, 20, or 21, insofar as it relates to the aforementioned offences of Chapter 2 of the Prevention and Combating of Corrupt Activities Act. The proclamation specifically refers us to PRECA. It specifically says you can find these offences in these parts. And if you do, then please go to court and declare that that is the case. That is exactly what we are doing. Our section 3 of PRECA is found in part 1 under F. Our section 17 is specifically mentioned in the proclamation. So we're not going beyond the scope of the proclamation. We are dead center in the proclamation. It is specifically mentioned. There is no words that can say, no, this is wrong. There's no reading of that section that could make us fall out of the proclamation. So we're definitely in the proclamation.
I was curious with the very narrow interpretation of section 4 by the respondent. this is of the Special Tribunals Act. And I'm not sure if you've looked at that.
I have looked at that, my lady.
My reading is correct there.
I'm just going to that act, my lady. So they say the functions of the investigating unit includes 4.1, and my lady is correct. It is to present evidence in proceedings before a special tribunal. Now, what we should also look at before I get to section 4, my lady, is section 8 says of the same SIU Act, powers and functions of this tribunal. And section 8.2 says a special tribunal shall have jurisdiction to adjudicate upon any civil dispute brought before it by a special investigating unit or any interested party as defined by the regulations. My lady, then they jump to the Rule 26, which talks about forfeiture, and they say it's unconstitutional because rules cannot change substantive legislation. But what they didn't do, they did a misstep. They failed to look at the regulations. And Regulation 5 specifically deals with civil proceedings. Regulation 5 is subordinate legislation, and therefore the rule flows from Regulation 5. And Regulation 5 specifically mentions forfeiture as one of the applications.
I mean, I don't even think you need to go there. Just the enabling legislation itself.
Yes.
Yes. Well, whether you look at Section 8 together with Section 4, the powers are couched in such broad terms. And
yes, my lady.
My reading is that the powers are couched in such broad terms, in terms of the kind of orders the special tribunal can make, that this limitation is a bit of a stretch.
Indeed, my lady, that is correct. Because the proclamation read with the act, my lady, 4.2 is only if you find criminality. Yeah. And that is for the NPA. It doesn't talk to improper conduct, unlawful activities. So if we find that, then we are well within our functions as the SIU.
So I think this is what I should have, because you didn't argue that, maybe I should raise it here with you. My understanding is that the nature of the forfeiture proceedings are civil. This is a civil remedy. It's not a criminal remedy.
Yes.
And all you need to do is to discharge your onus on the balance of probabilities. That already indicates the civil nature of the remedy. And I'm raising this with you because I think he needs to also address that when he replies.
Yes.
Is there anything else you need to bring my attention?
No, my lady, you are correct. This is a civil matter. The Act provides us with the release to bring a civil matter before you. Forfeiture is such a civil proceeding matter, and therefore we are well within our rights to come before this court. We say we have the necessary locus standi, and this court has the necessary jurisdiction to hear the matter. Thank you, my lady.
Let me just make sure that I've asked you some of the things that they have raised. So you've addressed me on the argument about proof of losses.
Yes.
So, right. Yes. So I understood also the argument was that you are asking for a declaratory order that a crime has been committed. Will you say something about that, please?
My lady, we are not seeking a declarator that a crime has been committed. My lady, those sections refer to proceeds of a crime or, very clear, or unlawful activity. Now, we are not going on the proceeds of a crime. We're not going on whether there was a crime or not a crime. We are saying it is unlawful activity.
Yes.
We are not here to review anything or deal with any criminality issues. That's not why we are here. We are definitely not asked to determine any criminality, but merely to look at whether there was unlawful activity. And if you find unlawful activity, then you must declare it as such. But we are not here for criminality. And that must be made very clear. We are not here for criminality at all.
Right.
Thank you, my lady.
Yes, a reply to that, to the submissions by Ms. Platt, please.
Yes, my lady. Maybe I should start from where she ended when she speaks about unlawful activity.
Yes.
And unlawful activity, my lady, is defined in the Poker Act. Maybe I can read it to my lady for the record. It's part of the definitions in section 1.
I just need to get there. This, are you now dealing with the prevention, PRECA or POCA?
POCA.
POCA. Right.
My lady, you will note that the Rule 26 of the SIU Act also speaks to unlawful activity.
Yes.
And unlawful activity is defined in POCA as a conduct which constitutes a crime or which contravenes any law. So, my lady,
Yes.
we would submit, therefore, that within the confines of what we call unlawful activity, one should look at the prayers that have been sought. In particular, what the applicant seeks that the relationship must find is to declare that the conduct of the first to third respondents to be in contravention of Section 3 of the Prevention of Combating of Corrupt Activities Act. Meaning that you must find that...
you can't do that. You can't do that. You are saying to me, hold on, no. You're saying to me, if I understand you, that I must look at POCA.
Yes.
Right? And you say that POCA defines unlawful activity. Did I hear you correctly?
Correct.
Yes. But how do you then, at the same breath, now ask me to refer to another piece of legislation? Let's advance this point that you are advancing, because I want to refer you to PRECA, because PRECA is against this interpretation that you are trying to convey to me. So just take me through sequentially, please.
Maybe that's too fast, my ladyship.
It's not fast, it's conflated.
Okay.
So take me through point by point.
I want to refer you where my ladyship, my colleague ended about unlawful activity. And I say the definition is found in POCA. What is unlawful activity? And POCA says it is a conduct which constitutes a crime. And it says, or which contravenes any law. That's what POCA says. So my lady, my colleague says to you.
Where are you reading this in POCA?
Yes. POCA, the definition of POCA in section 1.
Yes, let's show me where you are finding this.
Section 1 of POCA, unlawful activity means conduct which constitutes a crime or which contravenes any law, whether such conduct occurred before or after the commencement of this act, and where such conduct occurred in the Republic or elsewhere. That's a definition of unlawful activity. So, my lady, is my lady with me?
No, I'm not at all, because I'm looking at POCA, which is the Prevention of Organized Crime Act.
Yes. That's what I'm reading from on the definition of section 1.
Okay, so which Roman numeral defines this? Because I'm looking at the definition section.
It is just after property. The definition of property, and then the next one would be unlawful activity. Before it goes to section 2 of the offenses.
I don't have that. And I'm looking at poker.
But the one that I have has that definition.
No, I don't have that.
Generally, I'm not so sure that maybe we
Roman numeral
this
XV26 deals with property and what property means, and then it moves straight to section 2. And I just, perhaps from the authorities that you've given me, just share that with me so I can see where you are referring to, because I don't have that in poker. It's the prevention of, yes, sorry.
It was inserted by section 1C of Act 8 of 1999. I guess there was a further amendment later.
No, just share that. No, don't jump around. Just share that with me so that I make sure that I follow you. And I don't want to feel misled. And I also don't want to feel that I've misunderstood your submissions. I'm looking at poker and I'm not finding this definition. So if you are able to share on the screen with me where exactly you are referring to, that would be helpful.
Malak, we are trying to get to it. Malin, can we maybe come back to it? We're just trying to get it on the screen. Or we can maybe have it emailed.
You know how to share from the screen, do you?
My juniors know how to do it, my lady.
You go to the present button. And then wherever you are reading, it shows you start presentation, and then I will follow.
But I'm told that the computer that we're using is deactivated. We cannot be able to.
Well, that's quite interesting, but I must confirm categorically that this definition that you have referred me to is not one that is before me, and it's not in the list of the authorities that you have provided me. Right.
Yes, my lady. Yeah. There. Yeah. My lady.
And you say this is just go up, just go up for me. Right, no, it definitely doesn't accord with what you've given me.
But
I mean, I asked all of you to upload all your authorities, and this is not what I have.
my lady, that is what we have in terms of the act that is before us.
All right.
That's on the screen.
Okay.
It might be your ladyship's act doesn't have the.
It's not my act. It's an act that was provided by you to me.
No, we didn't provide the act to your ladyship. It's not us, my lady.
Who uploaded these authorities then?
It's not us, my lady. We didn't send the act to your ladyship.
All right, I think Ms. Platt wants to assist here. Please do.
Yes, my lady. I noticed that the act that we've uploaded is the old version. But I will see if I can get my junior to upload the newer version for my lady's benefit, and if we can do that quickly for you.
So all that preparation and all that reading was on.
My lady, it's only that section that was inserted. So everything else stays the same. It was just that section. But I will find. I only found out now that the section, the act that we uploaded was the incorrect one. But I do have the latest one. But I'll get them to do it.
Giving your colleague a hard time.
Sorry,
because authorities are loaded under the respondent's bundle of authorities, and there I am giving him a hard time, not over his own doing.
My lady, I'm not under the respondent's bundle of authorities, so I don't know where that one is. I know under our authorities, our one is the old one, but for theirs, I don't know.
Yeah, no, I'm looking at the 4th to 6th respondents bundle of authorities, so it gets worse. But see that as it may. All right.
Thank you, my lady.
Okay, thanks for that. Right, is there anything else?
Well, my lady, I was just referring to that definition and also mentioning that in Section 26 of the SIU Act, it refers to unlawful activity. That before you can forfeit finance, you need to find unlawful activity. But unlawful activity says there must be a crime or contravention of a particular law. And what we are saying, my lady, is that if one looks at the amended notice of motion, both of them in terms of poker and in terms of breakup, it says that the conduct of the first to the third respondent must have been in contravention of those sections, meaning that you must declare that they're in contravention, meaning that the elements of the offenses of corruption have been met, the elements of the contravention of money laundering must have been met. That's what it says. So you're declaring that they have committed a crime. And I would submit that it is not as watered down by my colleague that it is an improper conduct. No, it is not improper conduct. What they are asking you is basically to say that you must confine yourself to poker and break. That's where we're having an issue, my lady, in respect of the question of jurisdiction.
All right.
Those are our submissions, my lady.
All right. Thank you. We're going to adjourn until 11:30. I will give a ruling, and then we can decide how we move with the proceedings, if at all.
As a court, please.
So we adjourn until 11:30.
As a court pleases, my lady.
Right. We are back. Are all counsels here?
We are here, my lady.
Yes.
Okay, we've got the applicant, we've got the first to third respondent, and do we have the fourth to sixth respondent present?
Yes, we're here, my lady.
All right, so we are going to resume, and I think it's proper that I give a ruling on the submissions made on the jurisdiction point. And I just want to warn you that the rulings are not complete, but capture the salient points. And they are really designed to enable us to move forward with the proceedings. The reasons for the ruling will be dealt with extensively in the judgment. I have found, I've heard both of you and your representations, and I have found that the investigation and the current proceedings, especially this application, falls within the scope of the proclamation. And the question about the proof of actual financial losses, I find it's not a prerequisite to the order for forfeiture. And in my view, it includes correcting unlawful conduct that is a public wrong. And I find also that the forfeiture proceedings are not criminal proceedings, and they are civil proceedings in nature. And I also find that the restricted interpretation of the Special Tribunals Act, particularly if I read it with Section 4 and Section 8, as well as read together with both POCA and PRECA, and the regulations, this restricted interpretation is not supported by my reading of those pieces of legislation. And I find that the application to oust the Special Tribunal's jurisdiction is not well grounded, and I dismiss the application. And as I have said, full reasons will be in the written judgment, which supports my ruling. And with that in mind, having disposed of that, I am of the view that the forfeiture application deserves to be heard and ventilated, and accordingly, we must proceed.
As
the confused, my lady.
Yes.
My lady, then may I proceed on the application before this court? My lady, may I firstly start with the 4th to 6th respondents' heads of argument. I've read through it, and I'm sure my lady has gone through it as well. They raise a few points which seem to fall and follow the jurisdiction points. But following my lady's ruling, I think that should also fall away. But I just want to emphasize that we are not challenging the contract with Eskom. This is not a review of the contract that the 4th to 6th respondents have with Eskom. So when they say it is noteworthy that we have not filed or challenged or brought a review application, they are correct. It's not noteworthy because we haven't. This is not a review proceedings. You are not called upon to review any contract. They've gone extensively into the implementation of that contract. That is also not our case. We are not dealing with the implementation of that contract. That is not before you. That is not why we are here. So the implementation of the contract, whether it's find it nowhere in our papers, correctly so, because we do not make out a case for that. And then finally, my lady, they seem to suggest that you are asked to find that the money that they receive from Eskom in terms of a contract is proceeds of a crime. Now that boggles the mind and is nonsensical, because we are not here with Eskom's money that they give in terms of a contract, because that we know that contract stands, it's lawful, nobody is challenging it, so it can never be a proceeds of a crime. That is not what we are saying. So when that is raised, my lady, please note that that is not where we are going. Our case is very simple. It turns on one point, and that is non-disclosure. That is it, non-disclosure. The first respondent has an obligation in law to disclose. We will show you that he has admitted that he has not disclosed. Non-disclosure. Well, from the readings of...
Would it be okay if I direct you to deal with the matter in a certain way?
Sure, my lady.
I accept and I've heard and understood exactly what you say about what your case is not about. And I also hear you clearly when you say your case is grounded on a non-disclosure. Right. I think context is important. And I am of the view that for this particular matter, a matrix of all of the facts that the SIU brings or bases its application on are important. We don't need to do the full catalog, but an overview of the facts is, I think it's absolutely critical to take me through that, and in particular, also in relation to the defenses that are being raised, and then the issue of the contractual arrangements, the structure of the contractual arrangements between first, second, and third respondent, and in fact, all of the and the fourth to sixth respondent, because it's in that scheme, I think, that the questions of unlawful activity lie. So I would benefit a lot if you addressed me completely on that structure, and I hope that doesn't interrupt your own flow and of thinking.
No, my lady, fortunately it doesn't. I was making those brief remarks about the fourth to sixth respondent because it tied in with what we had dealt with under the jurisdiction, but my case follows exactly, my argument follows exactly the outline you have provided. My lady, let me take you to our heads of argument. It's 030-1, but I'm specifically looking at 030-8 under a factual matrix that we've given at paragraph 11.
Right.
My lady, as I go through it, I will provide my lady with the case lines numbers, because when we did this, it wasn't uploaded onto case lines, but I will give you the case lines references as we go through. My lady, I just want to mention that we have uploaded the new case, the new act, sorry. It is under case lines number 031-534. And that is the latest Prevention of Organized Crime Act, my lady. And the specific section dealing with unlawful activity is 031-536. So I just want to give you that reference.
Thank you.
My lady, if I start with paragraph 11, we've informed this court that we had received through a whistleblower that there are employees of Eskom or an employee of Eskom that has received funds from an Eskom supplier. And we are saying that that is the 4th and 7th respondents into the 3rd respondent's bank account. And when we did the investigation, my lady, we discovered that the 1st respondent had opened a bank account of the 3rd respondent, and I'll give you that reference, my lady. It's case lines 001-45 to 48. Now, my lady, if you look at that bank account opening document, if I could ask my lady to go there, it's on 001-46 specifically. Under the table, you'll find the words declarations.
Yes.
And you'll see it says, I, the authorized representative, hereby confirm that the information provided regarding the customer and controlling persons are true and correct. And we will inform the bank in writing of any change of this status within 30 days of the change of status. Now that's a declaration, my lady. And when you look at who signed that declaration, and it's there, Mr. Petrus Shaka Mazibuko, and he's signing in his capacity as director. So he is saying he is a director, which he is declaring to be true and correct of the 3rd respondent. Now, my lady, you will not find anywhere in this document where they deal with this allegation. They say he's not a director. He says he's not a director. But if he wants you to believe what he says, then he must explain why he said on this paper that he's a director. And then in a later paper, he says he's not a director. He would want you to take him at his word, but his word seems to contradict each other. So that is the first point, my lady. I'll go back to our heads. We are now on paragraph 13. And we say, around April 2019, transactions from the 4th and 7th respondent started flooding the 3rd respondent's bank account. Can I provide you with those case line references? It's 001-49 to 70 and case lines 001-83 to 105.
So are these the transactions from April 2019?
Yes. That's correct, my lady.
Can I just take you back on the point about directorship?
Yes.
I accept that he doesn't address this, and he will probably address us now in due course. But what I looked to see whether you checked the register of directors with CPC, which is the body that is charged with keeping these registers of directors with the company's office.
My lady, we don't have it in our documents.
There was a declaration, but it looked incomplete to me from CPC.
Yes, my lady. He may later not have been a director.
Yes.
We can take the point that even if he was a director at the time and later changed and he's no longer a director, I will still deal with the fact that he's a signatory on that bank account. And I will explain to my lady why that is important and where the non-disclosure happens. So it happens on 2 levels, that he's a director and that he's also a signatory. But also, further to that, and this we find is that he had to disclose that there was this arrangement to his employer. He had to be upfront that he holds an interest, and that interest may not necessarily mean a directorship, but he holds an interest in another company. And we're saying that is what he should have done. He said he didn't think it warranted disclosure because he was not being paid a salary. Now, he uses those words very carefully to say he wasn't paid a salary. When we do a Rule 35.12 asking him to provide his bank account details to show that he has received no other salary, he says, no, you don't need that. I'm not going to show this court my bank statements to show you that I don't earn a salary. You must take me at my word. Now, my lady, he doesn't say he doesn't receive any other income from anybody else. He says salary. But that does not exclude payments, income, that is not a salary. So he uses his words very carefully, say he does not receive a salary. But if you receive income from another party, you also have to so declare it. And he's told this court he's not going to provide you with any evidence that only he can provide, his bank statements, to show you that his defense is sound, that what he is saying is correct.
So what do you say to the complaint that the call for a disclosure is a reversal of the onus? I think there's that kind of argument that's been made.
My lady,
yes. I think
my lady,
reading is,
yes.
sorry, if you were to just to allow me to make the point,
Yes.
because I was curious about that legal point that they now say you issued a Rule 35.12 and they gave you what they did. But however, anyway, the complaint was that you are reversing the onus and asking them to prove their innocence. I think that's the kind of submission that's made. I'm finding it's related to the point of non-disclosure. So what do you say to that?
My lady, it's not a reversal, my lady. It's not a reversal of an onus. They bear the onus to prove their defense. So we bear the onus to prove and make out a case that they contravened an act. They, if they're raising a defense, bear the onus to prove their defense. So it's not a reversal. If they were not receiving any salary or any other income other than what they got from Eskom, they would have had no difficulty in showing you that. They will say, here's my bank statements. I have no difficulty. You go through it, and you will clearly see I have not benefited from anyone on any basis whatsoever. That is their defense. That is not an onus of proving that they contribute. Because he said up straight, he didn't disclose. That's my case made. He says he didn't disclose. That's all I need. He's already admitted that. But he justifies it by saying, and here's his defense, I did not disclose because I was not being paid a salary and I didn't think it warranted disclosure. So when he brings in a defense, he has to prove that defense. And he's chosen not to. So it's not a reversal of an onus, my lady. In fact, he has agreed with us that he has not disclosed. Therefore, on a balance of probabilities, you have to find that he did not disclose. Because it's now common cause that that is the case. So, my lady, you will see that we're now moving to paragraph 14 of my heads, where we say the first respondent is a brother of the second respondent and are both linked to the third respondent. That is case line number 009-5. So here you find that he is related to a party who is the director of the third respondent. He's a brother. And when I get to the ESCOM conflicts of interest policy, it will clearly say whether it is yourself that has an personal interest, whether it is a family member and they define it, or any other related party. So he should have disclosed that point, my lady, but he failed to do so. And the fact that he's a signatory on an account is even more pertinent that he should be disclosing such interest. Yes, he may not receive a salary, but that doesn't preclude him from receiving income or any payments in relation to that bank account. Now, my lady, we can move on to paragraph 15. I'm gonna just jump back to paragraph 13, where we say transactions from the fourth and seventh respondents started flooding in. Now, the fourth respondent has admitted that they are an ESCOM supplier, and we find in their answer that they have this JV agreement, which JV agreement they say was concluded prior to them receiving an ESCOM contract. They too have an obligation and a duty to disclose. They have not done so. And we address this in our reply, because in the supplier contract, they are enjoined to provide a declaration that they are associated with either an employee directly or somebody who is related to an employee or somebody who is associated to an employee. So all they needed to do, the fourth respondent, was to say, I have a JV agreement with the third respondent who happens to be associated with one of your employees. And if they had done that, that would have been the end of the matter. They have failed to disclose that they have a connection to an ESCOM employee. And that, we say, is the non-disclosure on the part of the fourth respondent, because they were duty-bound to so disclose, and they chose not to disclose. So, my lady, we then go on to paragraph 16. My lady, I'll just give you the case line reference because I need to unpack the second.
Sorry? I'm still on your head. Just trying to digest what you're saying against what I've read, because my understanding of what they are saying is that the connection that you are relying on is tenuous. Those are my words, not theirs. They're saying that that connection is tenuous because they are not a director or a shareholder of the third respondent. And of course, then there's the whole issue of the salary. And I seem to recall there's an issue also being raised that you are supposed to invoke certain provisions of the Companies Act. And I think they relate to piercing the corporate veil as such. I mean, I don't know what you were going to find if the version is that they are not a director, but be that as it may, I'm trying to stitch together the association and or connection, which would have triggered the duty to disclose.
As my lady pleases. My lady, can I refer you to 031-297. It's the supplier declaration of interest.
Yes, I've got that.
My lady, and if you look at page 298, so you'll say, let me just go back. It's either undersigned in my capacity as of the supplier, and that's when the fourth respondent fills in that part. Certify under oath that to the best of my knowledge, the information furnished herein is true and correct. I accept that Eskom reserves its right to act against the supplier named above or me personally in terms hereof, should this declaration prove to be false. Now, if you go to the bottom of that page, it says, for the purposes of this declaration, then they define private work and they define a commercial activity. If you go on to the next page.
This is page what? I've got 031297. The declaratory, the supplier declaration.
Yes.
So where exactly are you reading?
At the top, my lady, under the words declaration. So that's the part that they would fill in. I, the undersigned, and whoever would put it in my capacity as director, for instance, or partner or member of the fourth respondent, who is the supplier. And then they will put the supplier's name, and that would be the fourth respondent. Certify under oath that to the best of my knowledge, the information furnished herein is true and correct. So this is when you
are referring me to the supplier integrity pack.
Yes.
It's 331-297.
That's correct, my lady.
And I don't have this section that you're reading.
It's 305. 297.
I think what you can do to help us, you are being assisted.
Yes.
Your junior counsel can help share the references, so you refer to the correct pages.
My junior just came in to me to say he'll share it on his computer.
It could speed up the proceedings. Thank you. All right, so it's not 031, it's 035.
I think that's what he says, but I don't know if it says it starts on Earth. Let me just try and get there, my lady, before I give you another wrong reference.
And I mean, I'm counting his plate.
Sorry?
I'm counting.
Yes, my lady. Duly noted. I think make the screen slightly bigger.
Yeah, no, that's fine. All I need is for him. He could share the page with me on Caseline. So I just need to know the page. I just need to make sure I've got the right page and we're all on the same page.
Madar, you want to just provide the lady with the correct page?
Lady, I don't know if you can see the screen.
I have the screen, but
it's video with Advocate Clark SC was going through. I think it would be on 305.
Is it 0305 or 305?
It's just need to quickly go to it. The declaration should be 305 of the signed one. Yes, my lady, I just need to confirm with Advocate Clark SC whether it's Annexure A, the integrity declaration form?
Yes, it is the supplier integrity.
Yes, it starts on 031-303. And then paragraph 1 says declaration of interest. I/we. I don't know if
I've got that. I think that all of you need to now get on board with case lines. I mean, you are in Johannesburg, and this has been the system that's been operating for more than a year. There is a way of sharing information with me without, interfering with the screen and all of that. And at the lunch break, please just get somebody to help you to do that. You can share information with me on my computer without interfering with the proceedings. Otherwise, the time allocated will not be sufficient. So, please.
My lady, I don't know if it's not clear.
Yes, I've got that. But there's a better way than what you've done.
I understand, my lady.
Yes. Okay, so please find out lunchtime. I've got declaration finally, yes?
Yes, my lady. I'm just going to go to where the reference is. This one seems to be slightly different to the one I have opened in front of me. My lady, I will park this for now until I find it so that I don't waste any further time. But I will get the correct number, case lines number, and then I will provide it to you. What I will do is just read that section, and then I will provide you with the correct case lines reference. It says close family means persons related to the employee or director by birth, marriage, domestic partnership, adoption, guardianship, or the like, who may influence or be seen to influence the objectivity of the employee or director or related persons who may be influenced by the employee or director in their dealings with Eskom. So that's the close family definition. And then there's another definition that says associate means any person, i.e. a friend, rival, business partner, neighbor, or the like, who has a relationship with an employee or director who may influence or be seen to influence the objectivity of the employee or director, or who may be influenced by the employee or director in their dealings with Eskom. So we're saying in terms of that section, it broadly defines what the close family is, and it's very broad, the definition, as well as an associate. So the fourth respondent should have said, I'm in a joint venture agreement with the second respondent and third respondent, and they happen to be a close family member of an Eskom employee. So, my lady, we're saying it is under that we will find that they have that obligation to disclose, and that they have not so done. Because it doesn't necessarily mean that the employee has to be a director. It means that the second respondent happens to be the brother of an employee of Eskom. And all they needed to do is merely say, this is the case, this is how we are connected, and that should be the end of the matter. Eskom may have even said, well, it's so remote or it's so tenuous, as they may seem, that we're happy. But that's not the case. They said and it's declared to be true and correct. So it's a declaration. And they have misled Eskom by not disclosing. My lady, so let me proceed. And then we'll go to paragraph 17 of my head, my lady. Now, my lady, here we are saying that the third respondent has as its business cupboard installation and home improvements. That's what it says its business is. But it entered a joint venture agreement with the fourth respondent for intellectual expertise and technical expertise in the mining sector. And the second respondent doesn't say, I have the necessary experience myself in that sector because I've worked in the mining sector. He doesn't say that. The joint venture also talks to relationships within the mining sector. So when you look at that, my lady, you will see that the only person that has the necessary expertise in the mining sector between the first, second, and third respondent would be the first respondent. And my lady, we can go to the first respondent's answering affidavit, where he says he felt that he wanted to assist his brother grow his business. And that is paragraph 12, and it is 009-7. That's the answering affidavit of the first respondent. He says, it is in the foregoing context that I became a signatory on the bank account. I was merely helping my brother grow his business. Now, if he was helping his brother grow his cupboard installation and home improvement business, we would not be before this court. We would not be here today. But the third respondent has ventured beyond cupboard installation and home improvement and has now gone into the mining sector with a joint venture with another company who happens to be an ESCOM supplier.
Let's just go slowly with that, because there is there's something concerning for me with the structure of or the reasoning of that submission. So if the SIU say that if somebody, let's say a contractor or a supplier, wanted to venture into a different sector than that defined, that they are limited? Or should the question have been, just bear with me here, because there's something inadvertently limiting about the way that you are presenting this to me. Because we know that the question of skills transfer, opening markets to a range of people is a big question, and still a very relevant question. So what I'm wanted to pose to you isn't the question, what was the source of the skills for the expansion into the mining sector, rather than that he was in this business and then he ended up in this business, because
Yes,
that's an unfair way of putting it.
Yes, my lady. I was not going to suggest that they would not be able to diversify and move into different operations. They are well within their purview to do so. You're correct by saying it is the source of that experience that they were talking about, that they were going to be presenting. And that's where we are. So my lady was correct to say, who bears that source for the intellectual and technical expertise, the skill set, yes. Who bears that skill set that they were going to assist the fourth respondent in? And who bears the necessary skill set to provide the relationships that was required of the third respondent to bring to the JV in the mining sector. And the second respondent does not say he has that necessary skill set. He doesn't say he has been dealing in the mining sector for X period of time and has built up relationships and built up the necessary technical expertise or intellectual expertise. So he doesn't say that. It is nowhere to be found. The only inference we are saying you have to draw is that the first respondent said, I'm here to help my brother grow his business. And in so doing, I will help my brother in intellectual, technical expertise, and in the relationships within the mining sector. That's what we are saying. So it's the skill set. My lady is absolutely correct. It's the source of the skill set. So that they can venture into other industries. I'm a pro transformation and upskilling, so they can do that. But the joint venture doesn't say, the fourth respondent is going to upskill and assist the third respondent getting into the mining sector. It doesn't say that. It's the reverse. It says the third respondent will provide these expertise to the fourth respondent. Had it been the other way around, different story entirely. So my lady, we then move on to, I think I've dealt with 17 and 18. And then on paragraph 19 of my head, we say that the first respondent has not disclosed his interest to his employer. And that I think we have covered, my lady. So let's go to the next page, my lady, paragraph 20. The first respondent does not deny that there is a link between the third, fourth, and seventh respondents. So he doesn't dispute that there's this JV agreement. But my lady, let me just pause here for a moment. When I talk about the fact that it is now admitted and common cause that he did not disclose, I just want to tie that in with one of the prayers, because that is the building block from which we are going to proceed. And that is section 17 of PRECA. Now, section 17 of PRECA requires you to disclose an interest. If I can just get there, my lady. I think so. My lady, that is 031229. And if you go to section 17, my lady.
You say on page?
031229 is the start. But I'll get you the reference for section.
I've got that because I've got section 17. I just want to make sure that you gave me current legislation given the previous problem, because I'm looking elsewhere.
PRECA is the current one.
All right. I have section 17. Thank you.
Okay. So my lady, it says any public officer who subject to section 2, subsection 2, acquires or holds a private interest in any contract, agreement, or investment emanating from or connected with the public body in which he or she is employed, or which is made on account of that public body, is guilty of an offence. Now, when you deal with subsection 2, it says if you hold as a shareholder in a listed company, and if you're a public officer whose conditions of employment do not prohibit you from acquiring or holding such interest, or in the case of a tender process, a public officer who acquires a contract, agreement, or investment through a tender process and whose conditions of employment do not prohibit him or her from acquiring or holding such interest. Now, the first respondent doesn't fall under subsection 2, nor does he state that he falls under subsection 2 of section 17. So he's clearly a public officer. He's clearly employed by a public body, being Eskom. And he clearly holds or has acquired a private interest, my lady. And that private interest would be through the third respondent and the JV with the fourth respondent. And yes, he is prohibited from doing work outside of his employment, and he has to declare if he's receiving any income from any other business outside of his employment.
Just rightly, and let me make sure, and that interest doesn't have to be direct, am I correct?
That's correct.
It can be indirect, and the so-called beneficial interest.
Yes,
basically.
that's great, Mary.
Because I seem to think they seem to take the view that the interest needs to be direct.
Yes, it's not direct. It's not limited to be direct. Because otherwise your definitions of a close family or an associate, it could even have been your neighbor. And if it was your neighbor, you should have declared that it was your neighbor. So it's not a direct interest. It is merely a beneficial interest. And we are saying that as a signatory to the FNB bank account with money in excess of 11 million rand, that in itself needs to be declared, especially if you are the signatory and you have access to that fund.
Well, so he was the sole signatory,
yes,
am I right?
The sole signatory. Yes, there's no other signatory on that account. So he can do with that money as he pleases. But my lady, dealing with the signatory part, he says it's an investment account, but it's clear from the bank statement that it's a business account. It's not an investment account. He also says he became the signatory to help his brother because his brother has impulsive spending, sporadic withdrawals. So if that was correct, my lady, then the very next sentence that he says seems to contradict that yet again, because he says his brother runs the third respondent's businesses through many banking institutions, but he's not a signatory on any of those banking institutions. So it is fine for the second respondent to have impulsive spending or sporadic withdrawals from those banking institutions, but not from this one, where he is the sole signatory. It doesn't make sense, my lady. Something there does not tie in. So on that basis, we say the first respondent falls squarely, in section 17.1 of PRECA. And he has admitted that he has not disclosed this information. My lady, so now I will go through back to my heads of argument. My lady, I've dealt with paragraph 22, where we say they have not disclosed that they have this, even if it is, as my lady says, tenuous link, they needed to disclose it. And it is a declaration that they swore to be true and correct. And they were enjoined to do so, and they failed to do so. My lady, if you just go to the footnote on that page, footnote number 18, I then provide my lady with what the conflict of interest policy for the first respondent is. And it's very clear.
You can move on. You can
Okay.
move on with that.
Thank you, my lady. Then we go through to paragraph 23. The 4th to 6th respondents do not deny the first respondent as being the director. They only deny his involvement. They say in the implementation of the contract, he is not involved. And we are saying we are not in the implementation of the contract. We are not there at all. So we can accept that he may not be involved in the implementation of the contract as they have spelled it out. But where we are is they had a duty and a legal duty to disclose that connection. They did not. He had a legal duty to disclose that connection, and he did not.
I think you've made that point.
Yes, yes, my lady. And then, my lady, I will then go to paragraph 24, where we just set out the timing of these events, just to provide my lady with that context of when all of this happened. My lady, then I need to...
I'm going to interrupt you. Instead of taking me paragraph by paragraph,
yes.
I mean...
no, my lady, I'm done with
your time.
No, I'm done with that section, my lady. That was the factual matrix. I've done with section 17. I'm going to go quickly to section 3 of PRECA. Now, section 3 of PRECA, my lady, based on the factual matrix before you, shows that they need to obtain a gratification. Now, even if I look at what the first to third respondents say, what hurdles I have to jump, I will provide this court with me jumping over those hurdles. They say who obtains the gratification, and we have to say it is the first, second, and third respondent, because the first respondent is the only signatory on an account that he has liberty to spend as he sees fit. Who provided that gratification? And who provided that gratification was the 4th and 7th respondents, because they paid the monies into the bank account of the 3rd respondent. And it is the very bank account that is the 1st respondent's signatory. And the purpose was to benefit the 1st and 2nd and 3rd respondents, my lady. Because the mere fact that they failed to disclose this link is a contravention itself, and therefore is improper. And so when you look at the totality of the evidence, you will see that whether he had acted or not acted or done anything is irrelevant, because his legal duty is to disclose. You need not have found that, yes, he had spoken to somebody in the bid adjudication committee or the bid evaluation committee. My lady, he should have disclosed. They should have disclosed. That's their legal duty.
But the timing of the funds, if I looked at your timeline, was before...
During and after.
I beg your pardon?
It was before, during, and after. So it starts in April, after they had submitted their bid, and then it proceeds. The bid was awarded in November, and payments were made from April onwards, my lady. My lady, they also made withdrawals of on these accounts to the tune of, one was 974,000 or 975,000, my lady, during that time, and they made cash withdrawals. My lady, it wasn't a transfer, it was just shy of R1 million, but it wasn't a transfer, it was cash that they withdrew. And when we asked for documentation under Rule 35.12 to show us, they said no, not entitled. Again, it's not a reverse onus, my lady. They have to prove the defense. They have failed to prove that defense. They have failed to take this court into their confidence and say, no, but this cash was paid to somebody. And here is the cash receipt that we have done in our books to show that we have made a cash payment to Anthea Platt. And here's our cash receipts for it. And it's because Anthea Platt had rendered a service or had consulted or had done something, purchased something from the third respondent. They don't say that. There are just cash withdrawals taken out of the account, and we don't know why, and they have not said why. So we are saying, my lady, that even under Section 3 of PRECA, that we have made out a case for that. They then deal on that basis. They say you can't draw an inference because as triers of fact, you have to look at all the evidence. Now, my lady, we have shown you on all the evidence that we have shown to be true because there's no contradiction that there's a JV. There's no contradiction that there's a bank account. There's no contradiction that cash withdrawals were made. There's no contradiction who paid the money into that bank account. There's no contradiction on who holds the key to that bank account. So on all that basis, my lady, there is no contradiction whatsoever. It's common cause. The only contradiction they seem to state is that, well, you can't draw the link. That's the only thing they say. The facts are all there. Facts are common cause. Facts are all there. But they say you can't draw the link. And we're saying, of course you can. You are the trier of fact. You are entitled to draw that link. If there's nothing else that you can draw from, if they haven't presented you with any other explanation whatsoever, if it is the only probable link to draw, then you have to draw that link. And we are saying that that is the case. That is the only link. That they should have disclosed it, they failed to disclose it, they paid money for intellectual, technical expertise and relationships, more importantly, in the mining industry. And what is even more telling is the JV agreement says, please don't tell anybody that we're in a JV. When you do dealings, please keep it a secret. We don't want people to know that you and I are in a JV agreement. And that is clear from the JV agreement. So why wouldn't you want people to know you're in a JV agreement? Why must it be kept away from people you are going into business with? Why must it be hidden? They don't provide you with an answer to that. They don't say, well, it's for whatever reason. I can't think of one. I stretched my brain and I can't think of a reason why you would hide your partnership with somebody who is providing you with such important skill sets, intellectual, technical expertise, and relationships. But we're saying that's the only link you can draw. There is no other link. They haven't provided you with any other link. So we agree with their case of S versus Cooper. We agree 100%, but we say we've shown you the proved facts from which you are entitled to draw that link. My lady, before I go into section 4, I just want to deal with the analogy that they provided. And the analogy seems to say that a service provider of Eskom, lawfully appointed, if he decides to pay an employee of Eskom 200 Rand gratuitously, Eskom cannot be said to have suffered a loss. Now, my lady, that analogy seems to be very telling, especially because the fourth and seventh respondents say they don't know an Eskom employee, being the first respondent. But if you tied into this case, they would have you believe that the service provider, being the fourth and seventh respondents, could, after they have legally obtained a contract with Eskom, has decided to randomly, out of the blue, choose an Eskom employee, being the first respondent, and not give him 200 Rand gratuitously, but over 11 million Rand gratuitously. That can never be the case. Why would they randomly pick an employee of Eskom to gratuitously give 11 million rand. There can be no basis other than the link we have just shown you through the JV of the third and second respondent, in which the first respondent happens to be a signatory on the very bank account which we are asking you to forfeit. It is that bank account, not the other banking accounts of the third respondent. One bank account. One bank account where are payments being made. They cannot account for why those payments are being made, and they do not provide you with any defense as to why the first respondent is the sole signatory on that account. Then, my lady, if you go to our final relief, and that's section 4 of POCA. It says any person who knows or ought to have known that property is or forms part of the proceeds of unlawful activities, where unlawful activity is defined as conduct which contravenes any law. Now, we have shown you, my lady, that the conduct of the first respondent contravened section 17 of PRECA. That is any law. So we've shown you that he has contravened section 17 of PRECA. Therefore, it is unlawful activity because it is conduct which contravenes any law. We've shown you that the second, third, fourth, fifth, sixth, and seventh respondents have contravened their conduct in not disclosing this link, however tenuous or not, to Eskom, as they are obligated to do, contravenes any law as well, because that's section 3 of PRECA. We have two contraventions. Conduct which contravenes one law, two sections of that law. And we say that this, therefore, means that it is proceeds of unlawful activities. Not proceeds of a crime, proceeds of unlawful activities. So that unauthorized gratification, there's no evidence to suggest it was legally entitled to it. They say there's this joint venture, but they don't provide you with any proof of what the joint venture does. When we ask them to do so, they say you're not entitled to it. But it's their defense. It's not a reverse onus. It's their defense. They say, I have a joint venture agreement, a valid document, and I'm entitled to the money that I get. But they don't tell you why they're entitled to it, on what basis, how they invoice, how payments are made. They don't explain any of that. What they do explain is the contract with Eskom. But we are not there. We are not in the contract with Eskom. We are in the JV agreement. The defense they put up, the defense they have failed to provide sufficient evidence to this court to show that it is legally doing work.
So there is the issue, though, being raised that this is not the case you made out in your founding affidavit. You made this case in reply. And I'd like you to address that.
My lady, I tied everything into my reply, but I will take you to our founding affidavit, my lady. 001-12. And in that document, my lady, you will see at paragraph 19 and onwards, it's 001-23. We have set out, as I have taken you through in our heads, the very facts we rely on. We've gone from the whistleblower to the bank statements, to the signatory, to the fact that he didn't disclose it, to the fact that he didn't obtain it, the fact that they are suppliers, the fact that, and then we provide you with that evidence, my lady. But what we also have done, my lady, which they have not addressed, is if you turn to paragraph 4, which is on page 14, 001, page 14, paragraph 4 states And next to this affidavit is an affidavit I deposed to, providing the basis for this application, which I annex here to and specifically include in this affidavit. And if you go to that annexure, my lady, it provides the same details, but it just takes it a bit further, my lady. And that you will find, or at least it makes it a bit clearer, 001-32. That's the start of that annexure, the affidavit. And on 001-35, at paragraph 7, you deal with the investigation findings. And here they say it clearly, and it goes right up onto paragraph 14, where we say we have looked everywhere, we've searched everywhere, we cannot find a legal basis for why the fourth and seventh respondents are paying money into the third respondent. We've stated that.
I think that point might have really related to the JV issue, which seems to flow from their own defense.
Yes, it's from their own defense, and that's how I tied it together in the reply. So we've stated all of this in our founding affidavit. We've annexed all of these documents to it, and we say we've specifically included it in our founding affidavit. They haven't dealt with it. Now, if they haven't dealt with it, that's on them. But we've laid out that basis, and I've taken you through the factual matrix, and it's all contained in our founding affidavit. So, my lady, we have shown you that the first declaratory we seek is the section 17, and we've shown you that the first respondent has contravened section 17 of PRECA. We've shown you that the respondents have contravened section 3 of PRECA, and we've shown you that they have contravened section 4 of POCA. And therefore, my lady, we say that that funds of 11 million in the only bank account that the first respondent is a signatory should be forfeited, and that you should provide such a finding. Relief, my lady.
Is that?
Yes, my lady, that is it. If there's anything else you want me to address you on.
I think I was curious about the JV.
Yes, my lady.
And the services to mining industry. And I don't recall seeing, I only saw one contract, I think, in the discovery. Please, I'm checking in with you so that you can correct me. I only saw one contract which involved some direct contract between the fourth respondent and a mining company. It looked like a mining company.
I think that might be the PBT Shabalala or something.
Yes.
Yes.
I wondered about the connection between the mining industry and these contracts with Eskom. I think there is an issue about providing transportation services in relation to coal to various power stations of Eskom. Do you remember that?
Yes, my lady. I know there's a transport services agreement, my lady. And that's the contract. I'm not too sure if that's the contract you're referring to.
There is a contract that was put up. with the mining sector.
Yes, that is the fourth respondent's contract with Eskom. Yes. Yes, my lady. So that is the one that was awarded in November of 2019 to them. And that was the first contract that was awarded to the fourth respondent. The other contract that they had was as a subcontractor to another company who had the contract with Eskom. So they first acted as a subcontractor to another company who provided services in the mining industry to Eskom. But this one is the very first time they were the contractor awarded the contract. And that's why they say they went into this JV, because they didn't have that necessary expertise in that area, because they've only acted as a subcontractor.
Yeah.
And that's why they entered into the JV. They started paying the JV from April, and they then were awarded a contract in November.
Thank you.
Thank you, my lady.
Is that the sum total of your submissions?
That is the sum total of my submissions, yes, my lady.
All right. I know that we are set down for 2 days, and I'm very mindful of the time. So I think it's unreasonable to expect the next council to argue now. My suggestion is that we adjourn for 30 minutes lunch break and reconvene at 1:15. Would it be 1:15?
Yes, my lady.
I think a 30-minute lunch break, convene at 1:15, it allows sufficient time for most of the address. And I suspect that both respondents are going to take time, and they are going to need time.
Yes. As it pleases the court.
So we'll adjourn and reconvene at 1:15. And so we are resuming our proceeding, and because let's finish the address, and now we want to hear from the first and third respondents, and then fourth to sixth thereafter.
My lady, just briefly, can I just give you that reference number I was supposed to give you for the supplier declaration of interest? It is 010. Sorry, I'm giving you the wrong one again. 031-297. That's where it starts, and the place I was reading from is 031-303, and that is the signed supplier declaration by the fourth respondent, my lady.
Thank you.
And in the declaration they don't disclose. Thank you, my lady. That's all from me.
Is there an order that you have agreed which to address me? Am I correct to take the view that now an address will be from the first to third respondent? Would it be you, Mr. Mpapa?
As a court, please, my lady. My lady, just also to start with the aspect raised by my late colleague, Ms. Platt. He mentions cash withdrawals of 900,000, which is quite very sensational.
Just before you do that, I see that counsel for the fourth to sixth respondent is on, and I'm wondering, because he hasn't raised his hand, and I'm wondering if he wanted to say something to me, he wanted to address me.
No, my lady, I didn't. I just came on. Yes, I will disappear, but still listen to the proceedings.
Yes, that's how we agreed to preserve the broadband. I thought you might have wanted to say something, but I've noted that all counsels are here. Thank you. Yes, Mr. Mpapa?
As a court, please, my lady. I was just mentioning that my little colleague made a sensational submission to say that there were withdrawals, cash withdrawals from the account of the third respondent of about 900,000. And we want to submit that nowhere in the founding affidavit or the reply is such submission made. And we submit, my lord, that he didn't even point you to any bank statements to support that submission. And we want to submit that it is a wrong submission that she made.
Thank you.
At no stage, my lady, just to clarify, did the third respondent make a withdrawal of any cash transactions in the account.
Thank you.
As a court, please. Well, it would appear, therefore, that the applicant now has decided to abandon the whole arguments relating to trying to connect the first respondent with the implementation of the contract, the conclusion of the contract, and has simply based her argument in relation to the whole issue of non-disclosure. And we will also try to limit ourselves to that.
Thank you.
Maybe in relation to this argument raised by my colleague to say that there was some sort of an admission from the first respondent that he did not disclose the contracts or any agreements with the third respondent or even with the suppliers. Maybe we submit that in his founding affidavit, in his answering affidavit, which you will find on page 009 And I want to just emphasize
That's
page
the section.
0097.
Yes, thank you.
Oh, normally, I'm just incorrect. It's 0099.
That is perfect. Yes.
Yeah. But then paragraph 22, it says, I do not partake in any of the decision-making stages regarding the appointment of contractors. I was not even aware that the 4th and 7th respondents were doing business with ESCOM until I read the affidavit of the applicant. He's simply saying that I only became aware about the involvement of the 4th and 7th respondent after, when the papers were served on him. All this time he was not aware. So maybe we want to say that the whole issue of Section 17 therefore does not arise, because it is only when he knew that these were suppliers of ESCOM that the invocation of Section 17 kicks in. But I'll also come back to the interpretation of Section 17 later.
But should he have reasonably known, or to have reasonably known?
My understanding of Section 17 is he should have been aware. In other words, for him to make a disclosure, the disclosure is with the employer to say that are you doing business with any of the suppliers? And if you are not aware of that, why would you disclose? And we submit that
my question is slightly different. My question is premised on the fact that, unless you dispute it, but it seems indisputable, he's the signatory to the bank account. And monies, flew into the bank account. So when I ask, should he have reasonably known, it's simply because there's someone in charge of the bank account. It seems to follow that whether it is from a FICA perspective or whatever perspective, should know where the money is coming from.
My lady, he has already disclosed in his affidavit that he was not involved in the day-to-day operations of the company, and he was simply assisting his brother in respect of the management of the account.
Yes, but should he not have known where the money flowing into the account comes from, given that he was the sole signatory of the bank account?
Malady, he's simply saying in his affidavit he was not aware, and he's saying it under oath that I was not aware that the 4th and 5th respondents were doing business with ESCOM. And my lady, it makes sense if one looks at the when the JV was concluded, which was and the fact that the operations in terms of the ESCOM contract only kicked in 2020, and the monies which were paid into that account were not paid on the basis of the contract, which was later implemented in 2020. So as at the time of opening the bank account, clearly there were never transactions as at the time of opening the bank account with ESCOM working with the 4th and the 7th respondent.
No, that's, for me, that's not the issue. The issue is just the simple denial of knowing. And it's more, okay, so you say you don't know, but monies were flowing in and you were the sole signatory. Shouldn't you have known? That's really, it's as simple as that. Should he not have known where the monies are coming from?
Yeah, but he says he was not aware about the fact that the 4th and 7th respondent were doing business with ESCOM.
I'm not fighting with that. I'm not fighting with that.
But
Should he have known where the monies were coming from.
And I presume that if we were in a trial situation, it is a question that should have been asked under cross-examination. And your ladyship should have been able to make an inference from the responses that we have given. And
so I need to know. I need to know based on your submission around section 17 and what he asserts in his affidavit that he didn't know. And it's knowledge or ought to have known. So that's why I'm asking you this.
My submission is that from what he says in paragraph 22, basically he says, I didn't know. So where we speak it further to say he ought to have known, it does not arise from what he says positively in his affidavit.
That's all I'm asking for.
As a court, my lady, and let me just also clarify the issue of the seventh respondent, which is also quite important.
Why must I entertain that when the seventh respondent is not here?
My lady, it's what is in the papers of the parties.
I think I'm interested in the first to third respondent's case now.
All I'm saying, my lady, the basis of the applicant's case is that there was a non-disclosure. Now, it is relevant in relation to both the seventh and the fourth respondent. Now, I'm just trying to take your lady to the fact that we requested via discovery for contracts to be disclosed. And it has been conceded that there was never a contract between ESCOM and the seventh respondent. The seventh respondent was not a supplier of services to ESCOM. For that, the applicant has taken you through a disclosure required from a supplier in relation to the fourth respondent. He has never taken you through any supplier agreement, supplier or a request to disclose in respect of the seventh respondent. And I think it is common cause, my lady, that there was never any contract at all between the seventh respondent and ESCOM. Therefore, insofar as it relates to the seventh respondent, our proposition is that there cannot be any basis for the first respondent to have disclosed any interest in the seventh respondent because he was not a supplier. The requirement is you must disclose any business with any person who does work with ESCOM.
I must say I'm a little bit perplexed because one, I don't have an affidavit from the seventh respondent, and the seventh respondent hasn't opposed this, and so I don't understand why you are not confining me to the first, second, and third respondent's case. And why you're taking me there, because they're not here.
No, but I think in the monies which you are being requested today to forfeit all the amounts in the bank accounts.
Yes,
and those amounts,
accounts of the third respondent.
Yes, and those amounts were not only paid by the fourth respondent, but also paid in by the seventh respondent.
Yes, and the seventh respondent is not here to confirm or deny that.
But the position of the applicants is this, that they rely on section 17.
Yes.
And section 17 that we need to have disclosed the private interest. And there has to be a relationship between the work that is being done on behalf of the employer, where you are employed. But in this instance, what we are saying is that the seventh respondent was not connected to ESCOM in respect of providing any service, meaning that he did not receive, unlike the fourth respondent, he did not receive any monies from ESCOM directly. And therefore, we are saying that it can't be that an employee would be expected to disclose an interest in an entity whereby there is no connection with the employer.
How about disclosure in respect of the third respondent? How about the disclosure in relation to the connection with the third respondent?
Yes, my lady, the connection with the third respondent, that is an issue that is related. The connection with the fourth respondent is relevant, but the connection with the seventh respondent, my lady, does not arise in respect of the interpretation of Section 17. That is the issue that I just wanted to clear out of the way. And it doesn't appear that there is any contestation in regard to that. Therefore, in forfeiting the amounts in the account, they cannot be those amounts which were paid by the seventh respondent. Those are our submissions. Yes, ma'am. So that is just in short in respect of the seventh respondent. And we have raised it in our papers. It was not denied. If we then go,
I suspect Ms. Platt is going to reply and say, well, the duty to disclose seems much broader than just that, but I leave that to her. But I've heard you.
Yeah, and these are the complaints that we also made in our, the whole argument that we raised, that issues were more traversed in the reply than in the founding affidavit. That's one of the issues, my lady, which relates to the so-called cash transactions and so on. So I don't want to belabor the issue, but to say that we will restrict ourselves to the issues that were raised in their founding affidavit. My lady, just to then proceed to Section 17 of the Poker Act. Oh, I think it's for PRICA. Section 17 of the PRICA Act, my lady. What we read in terms of Section 17, my lady, is that you must acquire or hold a private interest. My lady, in acquiring or holding is a positive step, and a private interest in any contract, agreement, or investment. And my lady, that's the argument that you raised indirectly in respect of piercing the corporate veil. And we submit, my lady, that here we're dealing with the third respondent. And my lady, it is the third respondent who hold or acquired an interest in the JV agreement concluded with the fourth respondent. It is the third respondent who held an interest, my lady, in respect of the seventh respondent. It could not have been the first respondent who simply is a signatory in a bank account. My lady, how does he hold?
Yeah, but what would be the whole purpose of doing business? I mean, he controls the keys to the safe, basically, by being the signatory. I mean, when you control the money, surely that's the most significant part. He holds the keys to the safe.
We here, my lady, at our bar, we hold the keys to the account, but we cannot willy-nilly go and draw money, pay whosoever, unless there's a resolution of the board. Unless, my lady, we had resolutions, we said that this is how you should do things. My lady, it cannot be that you can run a company. It would be against the ethos and principles of company law for a signatory to simply pay as he wishes. That cannot be, my lady. My lady, we are submitting, therefore, that this issue in terms of holding a private interest relates to the third respondent as a juristic person and not to the first respondent as an individual. So, my lady, we submit. They are saying to us, the applicants, that we failed to come and explain what the money did, who was paid where, and so on, my lady. And we submit the whole question that in terms of the Section 4 of the the SIU Act, the SIU is enjoined to bring evidence before the court. It cannot say that we don't have evidence, but let them bring evidence so that we can show it to the court. No, my lady, it cannot apply like that. Once they investigate the matter, they need to then be able to get evidence. Nothing prevented them, my lady, to get the bank statements of the first respondent, in as much as they got the bank statement of the first respondent.
I think we are having.
Yes, we are bad.
I think we're having a little bit of difficulty with the network, so you froze. So you were saying nothing prevented them from obtaining the bank statements.
The bank statements from the bank account of the first respondent in terms of section 205 of the Procedural Act, in as much they obtained bank accounts of the third respondent.
In terms of section?
I think 205 of the Procedural Act. I'm speaking under correction. 205. Oh my.
I think the Act, the SIU Act, provides for the powers to subpoena and all of that. So I need not. We're dealing here with more the not criminal proceedings, but.
Oh, sorry. In terms of their powers, in terms of the SIU Act.
Yes, I think they do have those powers. They could have applied for a subpoena.
Yeah.
Are we still all on track?
There's a question. I think yes, I agree, Madidi, that they. As a court, please, my lady. And my lady, we are also saying that the first respondent in his affidavit, he says he never received any remuneration or any salary from the third respondent. And I think this is one of the key requirements in terms of the disclosure at work to say whether you are being remunerated or any further salary. And for the applicants to say that he did receive any remuneration or salary, they need to establish that. There is no evidence before you to say that any remuneration.
I think, Mr. Mpara, the problem is simply that he has the duty of rebutting and supporting his rebuttal properly. And as I understand what's being said is that to say I never received a remuneration becomes just a bare denial. And it places me in a difficult position because there is no weight to the denial. And also the problem is simply that it doesn't have to be remuneration in the way of a salary. It can be any other pecuniary benefit. And you place me in a difficult situation because you just gave me a bare denial without any backing, any evidence to rebut this properly. We've seen that the benefit is not confined to remuneration and salary. It could be, and if you look at the scheme of the Act, the benefit could be so indirect. It could be by gifts and other ways, So it's a little bit of a problem, this, unless you've got something to assist me here with.
No, my lady, our duty is to rebut evidence. In other words, evidence must be placed before you and we must rebut it. But we are arguing that the applicants have simply said to your ladyship that we had a private interest in the contracts, in the agreements, and so on. And we submit, my lady, in terms of what we have said to you, that we were not even aware as at the time. It's only as at the time when this application was made that we became aware. So we were never in any way there was never a possibility for us to be able to even know that we have to disclose in what Section 17 requires. So we will submit, my lady, that the applicant must be able to show, my lady, that according to them, Section 3, there was gratification which they are talking about, and gratification which could have induced us to act in a particular to influence. Although, my lady, they tried to move away from the fact that the issue of influence is relevant in terms of both the Corruption Act, the PRECA, and the POCA Act. But clearly, my lady, it is still relevant in terms of those two acts, that you should have at least tried to influence something. So we'll submit that the whole question in respect of the influencing, or in respect of disclosure, or whether we were supposed to disclose in respect of the contract that was concluded between the third respondent and the fourth respondent, would submit that that JV agreement was concluded and signed by the second respondent. We were never signatories of that JV agreement. The first respondent was never a signatory. It was only a contract between the company, which was represented by the second respondent, and the fourth respondent. So, my lady,
this is the problem here now. So what you're saying basically is the hush-hush clause in the JV agreement meant that the first respondent, even the first respondent, didn't know of its existence. That's what you're saying?
My lady, we are saying that the issue here is that the first respondent says he was not aware that the fourth and seventh respondent, actually is the fourth respondent, had any connection with ESCO. That's what he's saying. And we are now saying that the JV agreement, which in terms of Section 17 says you must have a direct interest in an agreement, so on. He was not even a signatory or party to that agreement. So, my lady,
I mean, does he have to be a signatory and a party in order to know of its existence?
But, my lady, you need to have an interest in that agreement. So if there's a requirement, if we had him signing that agreement, therefore it clearly show that he has an interest in that agreement. But he's not a signatory to that agreement.
No, but I'm asking, do he have to be a signatory in order to know of its existence?
It doesn't have to, my lady, to know that it exists. Yes. Now the question is nowhere in the paper saying that he knew or he knew about this JV agreement existed, or in the manner in which it was. My lady, he says in his affidavit, I was not responsible on the day-to-day operations of this company. The second respondent was. And that is what he's saying in his affidavit. And there is nowhere where he had signed the JV agreement. So I would submit, my lady, that strictly speaking, my lady, if one looks at Section 17, it really requires simply more than what a bank signatory is. You cannot say that because I'm a bank signatory, I hold an interest or private interest. Because there are many people, my lady, who are bank signatories, but they're not even shareholders. They don't even get dividends of their accounts. They don't get any money out of those accounts. They're simply speaking.
To effects of this case, I'm not going to speculate about things that happen outside of the papers that are here and the facts that I have here, because it's not helpful to me.
Please, my lady. My lady, further, my lady, if one has to go deeper, then is that there is no evidence that the first respondent derived any benefit from being a signatory of this contract. Allegations are made about withdrawals, but there is no connection at all that those withdrawals were made to benefit the first respondent. Therefore, my lady, his version cannot simply be rejected out of hand to say that I was helping my brother. It may seem very superfluous to say, how do you help your brother with the management of the account? But that is his version. And my lady, then we must be able to say, but from the outflow of the withdrawals, was there any direct benefit to him as an individual? And my lady, if we can't be able to establish that, then how do we then say that he falls within the purview of Section 17 in terms of holding a direct interest? Let your leadership properly set it out. It must be a beneficial interest. You must be able to benefit something out of that agreement or out of the contract or the investment, whatever it is. So would submit that there is simply no evidence to suggest that he benefited at all, directly or indirectly, from being a signatory to the contract. And my lady, we also want to say that to the extent that it is alleged that the first respondent was a director, my lady, it was never the case. The leadership posed a very good question to say, what does CIPC say about it? And my colleague did not answer. He says, no, it is not necessary that he be a director, even if he is a signatory. My lady, the fact of the matter is he has never been a director of the company.
Why did he declare himself to be such when he signed the form? Because I mean, there is the de jure director, and then there's the de facto director. Because it seems to me he made himself a de facto director because he declared himself as such when he opened the bank account. And to really control the financial keys is a very significant thing for a company, you know. And assuming the second respondent wanted a distribution or payments needed to be made, it means nothing can happen. No funds can flow without him. That's a significant position. It really makes him a very powerful player.
My lady, it is so. I mean, as I indicated to you, although your lady does not ask to veer on the issues outside the facts, but we are signatories of an account, but my lady, we don't have control.
You're not only a signatory. When you do sign, you declare yourself to be a director. The capacity in which you sign, you say you are a director.
My lady, the form, if you look at it, is that the completion of the form is not by the first respondent. He only signed the form.
That's the first time I hear it.
No, my lady.
That's the first time that's ever said to me.
But my lady.
That's not said anywhere in the papers. Never said anywhere in the papers.
Let me just then say this. As a matter of fact, the court there must be factual evidence before the court that he is a director.
He says he's a director when the bank form is signed. And you say he says he's not, but you don't say that anywhere else. I mean, even if that issue came by way of a reply, you were free to apply to supplement to deal with this issue. You say nothing of the sort.
Let me then move away from that, my lady, but let me just put it and say.
Advised to.
Yes. The evidence, and my lady, I'm referring you to page 010-40.
Yes.
And this is a copy of the CIPC, which clearly indicate who is the director of the company.
Look, as you are correct, I put it to Ms. Platt that there is that I looked at this as the SIPC form, at least from 2017, nothing, there's been movement, but you know, the problem is that would be the statutory director.
Yes.
Your problem is that there's a representation made on the bank form. You segue back to the point that he's acted as a de facto director, so it doesn't assist to to try and shape it one way or the other. He's acted as a de facto director, it seems to me, by the representation that's made on the bank form. And in fact, by the fact that, as I've pointed out, he controls the persons. If monies were needed for the business, let's say, no money could be paid unless he signed and did so. For me, in law, that's someone who occupies a powerful position, and and I need you to be clear where I'm standing, and I'm generally clear. That to me looks like a de facto director.
But then, my lady, what would it mean in law when you have a de facto director? The fact that I say I'm a director clearly means that I've said to somebody I'm a director and I'm not a director. In this instance, I mean, you're not going to be able to. I would have loved to indulge you more about this, but it is very difficult for me to accept that somebody who makes a representation that he is a director, and then over and above that is a sole signatory of a bank account where the engine of any business lies, is not a de facto director. It's going to be very difficult for me to convince me that, because he's behaving as one, even if statutorily he's not one, even if he's denying it. Why control the bank funds solely? Yes.
And I mean, your other difficulty is simply this, is that, all right, can I give you time for you to confirm, Virginia? I'm happy to do that if you'd like to.
Normally, I can just simply mention to the fact that the main issue here, my lady, is the whole issue of control. We don't have that evidence to say to what extent did he control the bank account. What transaction?
Sole signatory, Mr. Mpanga. Not only is it a sole signatory, the problem is on the facts here. With the same breath, it is said that this business has other banking accounts which are controlled by the second respondent and his brother. So the business is able to trade in other areas. Why then, the question is, why then control this one and not the others? So it really, on the facts, it makes that part unconvincing. It really gives me a little bit of difficulty on the facts.
Yeah. Normally, our submission simply is that the very fact that he said he was a director or declared to be a director was an error, my lady. It couldn't have been that he could have been a director in circumstances where in the CIPC he's not reflected as such. And that's why he has said that I was not the director of the company. That is our proposition. My lady, we want to submit, my lady, that just as a matter of clarity, I've already made the argument in terms of the Companies Act that we have referred to, and I don't want to belabor it to the effect that the third respondent was acting as a juristic person on his own, and therefore one could not impute the activities of the third respondent to a signatory of the bank. And my lady, if one on page 05428 of our heads, paragraph 50. No.
Yes.
Actually, is 31. It's 31, 32.
I beg your pardon, you broke up there.
054-30 of our heads.
Yes.
And then we just referring to the judgment there of all pay consolidated investment on paragraph 53. I see my lady is, my lady, we simply say that mere suspicion of malfeasance is not sufficient. And we want to submit that the whole argument with, in respect of saying, but the first respondent is still are silent on other issues cannot be sufficient. We submit that in terms of section 4 of the SIU Act, the SIU is enjoined to bring evidence before you. And therefore, we cannot be expected, based on the whole issue of suspicion, allegation that there were cash transactions, there were no cash transactions, allegations that we never came to substantiate or at least produce who did we pay, my lady.
Yes.
And we will submit that that evidence will be clear in the bank accounts of the third respondent. The SIU, if it wanted to bring evidence before you, it would have come with those bank statements and say, here it is. The first respondent was paid X amount of money. Therefore, he benefited. But no such evidence is there before you. So we acquiesce and agree, my lady, with the judgment as per Nugent here, when he says that something more must be presented, because to be able to attach an amount of 11 million rands from an account of an entity or a company, my lady, it is not a small feat. Quite clearly, there must be something tangible that must be brought forward by the SIU to say that this money clearly is money which was out of corrupt activities. Now the applicant has come back and said, no, we are no longer saying that whether the contract was implemented or not. It's not about whether the contract was unlawful or not. They say the contract was lawful, the contract was performed. The only problem is that one official did not disclose. The official did not disclose his interest in contract and so on. Would submit money that
the non-disclosure issue is also applies to the fourth respondent. It's a reciprocal obligation to disclose both by the third and the fourth respondent and the first respondent. I mean, it's I don't know what you want to do with that. The duty to disclose, we've seen, unless you want to read me a different supplier declaration and a different conflict of interest policy, but the duty to disclose is reciprocal between both ESCOM supplier and also both ESCOM's employees must disclose.
But the fourth respondent, actually, I mean, when he gave a bid in 2018 for the contract, it was at that stage that he was supposed to disclose. Meaning it's at that stage when the contract was being adjudicated that he was supposed to disclose his connections with any official of ESCOM. At that time, there was not even a JV agreement between the third respondent and the fourth respondent. Now
Is that duty not ongoing? Is that duty not an ongoing duty?
It is once they award you a contract, they want to know that is there somebody who's got an interest. It's at the time when you submit the bid, those documents must be in your bid documents. So therefore, my lady, it will be too onerous for you to expect that the fourth respondent should have. And
I would like to think it's an ongoing duty to disclose because business circumstances change every time and every day.
No, my lady, for you to be aware of the contract is at the time. Even my lady, if you apply for a judicial appointment, it's at that time when you have to disclose. I don't see how.
I'm not going to ask you to stray into my territory because I assure you, it's it is not as you will say.
Yes.
The duty to disclose is an ongoing duty.
Lady, it has to be somewhere else. If procurement processes of ESCOM, those are procurement processes. So the applicant should have then said to you that in terms of the policy of ESCOM, the disclosure is ongoing in respect of suppliers. That is not the evidence before you.
Well, I'm not going to take to the disclosure clause, but I think I looked at it. But you can move on because I still need to accommodate. I want to accommodate all your arguments, and I also want to accommodate.
Malady, I think let the fourth respondent explain himself more. I don't want to
yes.
stray in his territory.
Yes.
Because I don't think I'm remunerated by him to argue on his behalf. But Malady, our submission therefore would be that in respect of the issue of disclosure, we would say that in our affidavit, we have indicated that we only became aware long after the fact that the fourth respondent was doing business with ESCOM. And we would submit further that Section 17 does not find application because it must affect the company directly. And as a public officer, the first respondent did not have any duty to disclose because he didn't have any relations in respect of any contract, agreement, or investment. Those are our submission, my lady. Unless you want to hear us on any other issue, our heads speaks for themselves, my lady. We submit that makes up our case.
Yes. Do you want to address me on your earlier point about there being no loss suffered?
My lady, in terms of yes, my lady, that issue has now been abandoned by my other colleague because he simply wanted to focus only on the issue of supply. Therefore, we were arguing it on the basis of the fact that we didn't influence any contract and the implementation of contract ESCOM just find loss in the piece of the contract. So it is no longer relevant in respect of that because they are not relying on it.
Would you care to tell the tribunal what the source of the skills that the third respondent had in the mining sector?
My lady, when you run businesses at that level,
I beg your pardon?
The thing is that when you do business at the level that the applicant the third respondent was performing, it cannot be that it can be said that the second respondent had not the requisite skill in respect of, because it was not only relating to mining, but it was related to other fields in terms of marketing and promotions. So it was quite a wide agreement. So in other words, insofar as he is can be able to market the services of the fourth respondent to mines and so on.
More now the technical expertise. I think the issue of the intellectual property and the technical expertise that the third respondent offered it's left not clearly explained, and that's why I'm asking you to address it. And I think you heard me engaging with Ms. Platt around the core business and what the business as a cupboard builder or construction related type business. So it's simple. So according to you,
yes, mining maybe
the source of the intellectual property that the third respondent offered to the fourth respondent to cause the JV, the respective contribution in the JV.
But as a company, maybe you are not reliant on the directors of the company in respect of doing the works. You are able to subcontract the works insofar as they want to what you call, they want a service. You are able to subcontract that service, maybe. It is not every time that you have all the requisite skills, but you are able to point them to the right person.
Very clearly in the answering affidavits.
But we submit that it followed to the effect that if one looks at the founding affidavit, what do we have to respond to? But those issues were not raised in the founding affidavit. And would submit, Maliki, that it would have been unfair for us to deal with them extensively in our answering. That's why we want to submit that a company as a company is able to outsource some of its activities, and that would be my answer.
Thank you, Mr.
There's a question.
We are right. Thank you. Let me consider you, Mr. Ramawele.
Thank you, my lady. It appears to me that the applicant's case now is about the fact that the fourth to the sixth respondents have failed to declare their interest when they apply for, when they tendered for the contract that was awarded to them. But all sorts of allegations were made in the founding affidavit. But the only allegation that relates to the fourth respondent, and my lady, when I say fourth respondent, I include also the fifth and the sixth respondents.
Yes, I understand. I understand it to be so.
Okay.
Yes.
The only allegation in relation to the fourth respondent about this particular issue, where reference is made to ESCOM, is on page 00136. Paragraph 11, my lady. If you read there, it says it has been confirmed with ESCOM that CLM is a current vendor to them with vendor number 11088411 and standard bank account number C, there's the Central Supplier Database registration report for CLM attached as annexure JSN 18. FNB has not been able to provide the SIU with the contra account information at the time of deposing to this affidavit. In other words, my lady, there is no way in the founding affidavit where the applicant makes an allegation that the fourth respondent has failed to declare. Absolutely nowhere in the founding affidavit. The only instance where you find the fourth respondent making an allegation about failure to declare is in the replying affidavit. And in the replying affidavit, you will find it at page 01017. Paragraph 20.1, where the applicant says, this answer does not assist the 4th to 6th respondents in relation to section 3 of PACOCA, in that what is very apparent from the answering affidavit of the 4th to 6th respondents is the role that the 2nd and 3rd respondent played in obtaining the ESCOM contract. My lady, the point which I'm trying to make here is, if you read the founding affidavit of the applicant, the factual basis upon which the relief is sought or the allegations are directed against the 4th respondent are missing. The one in relation to the failure to declare are missing. What you have is a declaration of interest which is attached to the replying affidavit. But my lady, I don't have to persuade you that a litigant cannot make a case in reply. I don't think I should go there. I've referred to case law to that effect, and I don't think I should even go there. The fact of the matter is, as I say, that what the applicant suggested, which the applicant has now abandoned, was that the 1st respondent played a role in assisting the 4th respondent to obtain a tender. That's what the applicant says. That's what the applicant said. And that's, in fact, my lady, the factual basis upon which this relief is sought is very confusing. Because on the one hand, the applicant says you failed to declare. On the other hand, the applicant says, but the 1st respondent assisted you to obtain a tender. Or you couldn't have entered into the mining sector because you lack experience. So what is it? Is it lack of experience which came in the form of the 1st respondent? Or is it the failure to declare? So we say for the 4th respondent that the applicant is uncertain about the basis upon which this application is brought. The applicant, in argument, moves away from what it is in the papers. But having said that, my lady, I will submit first that the factual basis upon which this application is based, nevertheless, does not support or does not justify the tribunal in granting a final relief. Maybe if it was an interim relief, maybe perhaps, but not a final relief. And I'll start with the factual matrix that my colleague for the applicant had referred to. The first one my lady, was that they had received information from a whistleblower. But then my question is, yes, you received information from a whistleblower, but how does that take your case any further? Maybe it is just additional facts that you have to put in a founding affidavit. But for my colleague to say that those are the factual metrics, that you received information from a whistleblower, in my humble submission, it doesn't take the case any further. And then what she did not mention, and I don't want to refer you there because it is on record, is that it is also stated that evidence shows, this is the applicant, evidence shows that the 5th and 6th respondents may have contravened Section 3 of PACOCA. And then you will find, my lady, at page 00125. But I don't want to read it because it is there on record. She can in reply say that it is not, as she can in reply dispute this. And also, and I'm dealing with the factual matrix, my lady. And then she says further, that is the applicant. Evidence shows that the 5th and 6th respondents may have contravened the provisions of Section 4A and B of POCA. And that allegation, my lady, you'll find it at page 00124. Now, the two of them, they're not saying that the 5th and 6th the respondents did this or that. There is no positive allegation against the 4th respondent. It's a speculation. There is no other way that you can phrase it. And the applicant cannot run away from it. It is a speculation. It is a conjecture.
So what is the speculation according to you?
The speculation is that the 4th respondent may have contravened Section 3 and 4. And this is in the founding affidavit.
Is it not based on the payments made? Isn't it that there are payments made into the 3rd respondent's account by the 4th respondent?
Yeah, but what do we have? Sorry.
Just walk with me. Just walk with me slowly. Walk with me here.
Okay, sure.
The payments are not disputed, right?
Yes, yes.
The 4th, and represented by obviously the 5th and 6th respondent, did make payments into the 3rd respondent's bank account, right?
Yes.
So there's no issue there. That's common cause. All right. Then the 4th respondent entered into a JV.
Yes.
With the 3rd respondent.
Yes.
Right. And certain payments, after the payments were made, tenders, were submitted and all of that, there's no problem there, right?
Yeah.
We are all on the same path. And then at some point, the 4th respondent became a supplier to Eskom, am I right?
Mm-hmm. Yes.
We're through together there.
Yes.
Right. And then, based on the relationship via the JV with the 3rd respondent, since the case that's been made is that the full extent of that relationship, direct or indirect, should have been disclosed. The 4th respondent had a reciprocal obligation to disclose. Is my understanding of the case so far, yours and mine, the same?
Yes,
right.
Except the major issue there, except the fact that the issue of the disclosure for the 4th respondent is absent in the founding affidavit.
You did say that.
So as far as that is concerned, the obligation, whatever obligation that may have been there for the fourth respondent to disclose, that is not contained in the founding affidavit.
Right. You've said that. I just want to follow your two other submissions around POCA and PRECA, and I just need to understand that most closely.
No. I was just highlighting the evidence of the applicant. I was merely just highlighting what the applicant says in its founding affidavit, because it is in your founding affidavit that you've got to make your case. That's what I was trying to highlight, that this is what the applicant is saying.
Yes.
And then the applicant says also that there is no evidence or explanation that these amounts received in the bank account were anything other than unauthorized gratification within the meaning of PACOCA. Now you see, that is a conclusion. That is a conclusion of fact. That is a conclusion drawn from nowhere. It's a conclusion drawn from nowhere, because the applicant is not in a position to draw that conclusion. You can just draw. You can draw that conclusion.
Explanation for all the parties were served to disclose certain information. They made partial disclosures. So what is then the fourth respondent's explanation for the payments that it made? If you remember, the issue was that there seems to be no services rendered.
Yes.
I would have expected, other than that one invoice that came out of nowhere, I would have expected that at the very minimum, it wouldn't be difficult for the fourth respondent to present invoices and say, these are the invoices, these are the services that were rendered. I didn't find that on the papers.
My lady, if you allow me, I'm still coming there.
Okay.
But I can just briefly mention that in regard to that issue, the reason why it was just one invoice is not because the fourth respondent is only in possession of one invoice. It's because in the answering affidavit of the fourth respondent, payment reference was made in terms of the request which was made. The request which was made necessitated the disclosure of that very invoice. And we said so in our papers. We said so in our papers in our response. So in other words, in terms of 3512, if you ask for a discovery, I'm not obliged to give you an ACLIVA file of documents, because I can only give you the documents that you require, or which, in terms of Rule 3512, I'm supposed to discover. So that will be the argument. And then, among other factual metrics, which you will find at page 01024, the applicant says the fourth respondent lacked experience to have been awarded a tender by ESCOM. Now, you see there, it brings in the role of maybe the first respondent or the second respondent, by somehow it does imply that, when the bid was submitted or packaged, somehow the first respondent was involved. But as you can now hear today, the course of action has surprisingly moved a mile, because now we are only confined to a narrow issue of failure to disclose. We are no longer being accused of being assisted by the first respondent. So these are the facts which I just want to bring to your attention in regard to the applicant, that the applicant does not know what its case is about. It keeps on shifting the goalpost as the matter proceeds. And the last issue on the factual matrix is the failure to declare, which I've already dealt with, and also that the applicant says that the first respondent somehow was involved. I've dealt with that particular issue. And but in regard to the failure to declare, may I deal at once with the issue that you raised with my colleague, Advocate Mpaha, to say that the bid itself was submitted on the 24th of June, 2018. And then the JV agreement was signed on the 11th of December, 2018. And I think what Advocate Mpaha was trying to say was that the fourth respondent could not have disclosed anything because when he entered into a JV agreement, the bid had already been submitted. And I heard you saying to him that, but the disclosure is an ongoing obligation. Is that how I understood you?
Can you make your submission?
Yes, ongoing obligation. My submission in that regard, my lady, is that it may well be an ongoing obligation, but let us look at the course of action of the applicant in these papers. Let us look at the course of action of the applicant. The course of action of the applicant confines the applicant only during the submission of the tender.
I don't understand Ms. Black to have said that. She said before, during, and after. I think those are the words that she used.
To disclose.
That's how I understood it.
Well, like I indicated, the
yes, this was in relation to this complaint about a gratification.
Yeah, I was just being reminded that she said that
payment happened before, during, and after.
She was talking about payment, my recollection.
Yes.
Yeah, payment, not disclosure. Not disclosure of the interest.
Yes.
So that's how I've just been reminded that she was referring to the payments.
To the payments.
And my answer to your question to Advocate Mpaha about an ongoing obligation, it's simply that the course of action, in other words, the course of action, my colleague for the applicant said to you that we are not concerned about any other thing except the failure to disclose. And then we say, if you're concerned about when the bid was submitted, if you're concerned about that, but when the bid was submitted, the JV had not yet been signed. But that is, my lady, in the event that you find that the applicant can make its case in reply. Because that is another major issue that we raise. If you find that a litigant cannot make a case in reply, as the applicant is trying to do, if you find that we don't even, the issue of the duty to disclose does not even arise. If you find that, because that cause of action is set out in the replying affidavit, and you don't have any response by the fourth respondent, which is extremely prejudicial.
Should I take that submission seriously?
Yes. Yes.
So why didn't you apply to file a further affidavit? Because you can, if you think you are being prejudiced.
You can, but why should an applicant deliberately? In fact, in the case that I've referred you to, the Mostert and the First Rand Bank, it clearly suggests that you should not allow it because it lists 4 factors which you may consider in allowing that particular issue, and for instance, it says whether all the facts necessary to determine the new matter raised in the replying affidavit were placed before the court. If you have to exercise your discretion to allow the replying to allow that particular issue, then you have to deal with this issue. And we say on this point that not all the facts were placed before the court. And the second one, whether the determination of the new matter will prejudice the respondent in a manner that could not be put right by orders in respect of postponement and cost. We are already in a hearing, and I cannot imagine how the matter can be postponed whilst we are arguing the matter. And the most important aspect is whether the new matter was known to the applicant when the application was launched. The applicant did not address you on this issue. Surely she must have known. She must have known. She must have known that there is a declaration of interest by ESCOM. It's something that she must have known. I cannot imagine the basis that she can provide to the tribunal as to that the applicant was not aware. And the final one is whether the disallowance of the new matter will result in unnecessary waste of cost. So our submission is, yes, you may allow that issue of the declaration of interest, but subject to a discretion being exercised in the manner that in the Mostert it was set out. And we submit that on a proper analysis of the papers, that the applicant is not entitled to rely in respect of the fourth respondent on the failure to declare. And then we also say that on the common cause facts which are before you, the applicant is not entitled to relief. And the first one, I'm just going to deal with it briefly without making any argument, because you've got to dig into it to be able to make a decision. The first one is merely that this particular tender was awarded by ESCOM pursuant to a competitive bidding process, and which is not in dispute between the parties. But I'm going to go beyond that because we have to address, as the applicant, we have to address the issues we have to deal with the issues that the applicant is raising. And the other issue that I want you to take into account is the fact that in April, the first payment that was made to the fourth respondent was in April 2019, whereas Eskom only paid the fourth respondent almost a year later in February 2020. So I just want you to take into account that particular issue, that you have a payment which is made in April 2019 of about 300 Rand, and then 300,000 Rand, and then almost a year later, the fourth respondent only gets payment from Eskom. It may not be conclusive of the submissions that I'm making that the first respondent was that the first respondent was not involved in any way in the awarding of the bid. It may not be conclusive of that, but it does lend credence somehow. It's a positive factor on behalf of the fourth respondent, just for you to consider that payment was made way too earlier, way too earlier. Whatever weight that you attach to that factor, I will leave it to your discretion, but I just want to point it out to you. Now, when it comes to the equivocation,
Hold on. The reasons for those earlier payments, you say you are not obliged to tell us what they were.
I'm coming to them.
All
yes,
right.
I'm coming to them. The other issue, which for us, the fourth respondent, is a very important issue, is the fact that, and I can see why it makes sense why the applicant has simply now, how can I put it, shifted the goalpost. Because on the main issues which are in the founding papers, they were not able to deal with them. And I just want to refer you to our answering affidavit, where we said the first respondent, as senior manager coal operations, is nowhere near this process and has no control or influence over any aspect of the execution of the contract concluded between the fourth and third respondent. And this is what we say at page 00965, paragraph 24. And the response of the applicant in that regard you'll find it at page 01037, paragraph 67, where it says, I note the contents of these paragraphs in relation to how the Eskom contract is implemented and deny any inference and allegation. Now, the other issue that I want to bring to your attention, which is not in dispute, is that the contract which has been concluded between Eskom and the fourth respondent is similar to is exactly the same as other contracts. It may not mean anything, but it is exactly the same contract. It's the rates, everything, it's exactly the same. So this is, again, another aspect that I want you to consider when you look into whether you should allow the late introduction of the failure to declare. You should look at the explanation, the explanation or the evidence of the fourth respondent, and then when you exercise your discretion. Now, to come to the issue that you have been raising
Now, something just cropped up in my mind, and I just need to clarify that with you. So when you say to me that, all right, this is around the issue of potential influence. So when you say the contract is exactly the same as that concluded with other suppliers, what do you base that on?
There is a letter from the Chief Executive Officer of.
Okay.
Yes,
this
yes.
Is about rates.
Yeah, from that letter where he says, yeah,
Okay.
yes, I base it from that letter from the Chief Executive Officer.
All right. So are you saying the question of involvement in procuring the bid is connected with the conclusion or the terms of the contract? Are you implying that if there was involvement, the terms of the contract would have been different or favorable or whatever? What are you saying?
The argument that I'm making is that because the applicant is not so sure about the basis upon which its application is based, it has abandoned its previous stance that the first respondent was assisting the fourth respondent, or the first respondent assisted the fourth respondent in the acquisition of the tender. Mm-hmm. So the point that I'm trying to make is it's a shifting of the goalpost. Now you realize that this one cannot stick. Now you want another one, and you introduce it in a replying affidavit. That's why I say the unfairness comes in, because of the shifting of the goalpost. Now to the issue that you have asked me more than twice about the service that in our answering affidavit at page 00972. My lady, 00972, I'm just reminded that there is an issue relating to the transportation contract between the fourth respondent and the miners and the mining houses. And I was just reminded that my colleague for the applicant had indicated that it was a subcontract, and that I must just put it on record that it was not a subcontract. It was actually it was a transportation contract to transport the coal from the mining houses to the power stations of Eskom. And this is the same contract in reverse, which was awarded to the fourth respondent, because in this instance they were now supposed to transport the coal from the from Eskom to
from the mines to the power station. From mines to the power station.
Oh, yeah. I've just been reminded that they were supposed to transport the coal from the mines to the Eskom's power stations, whereas on behalf of Eskom, whereas previously they were transporting the coal from the power from the mines to Eskom on behalf of the mining companies. So, but be that as it may, I was referring you to the issue that you have been raising, 00972. If you look at paragraph 48, this is the fourth respondent answering affidavit. It says, during the duration of the joint venture agreement, the third respondent provided CLM with technical and intellectual expertise as contemplated in the agreement, which created an obligation for CLM to make payments into the third respondents as contemplated in clause 4 of the joint venture agreement. And if you look at what the response of the applicant is to this positive allegation, you'll find the response on page 01038. You'll find the response, my lady, on page 01038, paragraph 73. It says at paragraph 45 to 54, which includes paragraph 48. It says, I deny the content of this paragraph. I refer to what I've stated above in paragraph, and it doesn't say anything there. It appears it is not even complete. Now, the point that I'm making is that the applicant, the fourth respondent, has made a positive allegation about this particular issue, and this issue it's a mere bare denial by the applicant. It's a bare denial, and as you had indicated earlier, there is a copy of the invoice that was submitted by the third respondent, fourth respondent, and that you will find at 07746. In fact, it's from the third respondent to the fourth respondent. So what we are saying, my lady, is the applicant has to make its case. The applicant cannot succeed by merely making bare denials, because this is how the applicant is approaching the issue of the service which was rendered by the third respondent. It's saying in his papers, I deny, and nothing more. Now, we know that it is tried law that wherever there is a...
You rely on this single invoice, basically. You rely on this single invoice to say services were rendered over a period, and you say you are not entitled, they are not entitled to know anything else other than in relation to the Eskom services. Do I understand you correctly?
No, I'm not saying we are not saying we rely on this particular document only.
Yeah, because you didn't give them any other documents.
Yes. May I then refer you then in that regard to page 0772. At paragraph 2.3, when the request for invoice is made, this is what As you can see at paragraph 3.2 on page 0773, we say a copy of the tax invoice from the third respondent to fourth respondent is attached and marked B. But if you look at paragraph 2.3 on page 0772, we say there is no mention of invoices from fourth respondent to ESCOM, and thus the required documents are not a subject in terms of Rule 3512, as no reference is made to such documents in the answer.
Is that you say because you confine your responses, they're not entitled to any of the other like services in relation to the previous payments, even before the tender and awarding of the tender and all of that. That's your approach. That's how I'm understanding it.
Well, my approach, our approach was in terms of the provisions of 3512, to say that if you say we must comply with certain requirements in terms of section 3512, we will. But please don't do a fishing expedition, because that's what the applicant appeared to be doing. Because like for instance, the applicant even asked for they asked for way bills. They asked for way bills related to transportation. And we said to them, well, those way bills are in our possession, and you can come and inspect them. They never came. They never came.
Interested in your, yeah, okay, that's fine. I get what you're saying. So yes. You can. What else is there?
So what then we are saying is that if you look at the entire factual matrix in this particular matter, how do you then say that there's a, how do you then say that the money that was paid into the third respondent constitutes unlawful proceeds? How does it says proceeds of unlawful activity? How then do you base it? On what do you base it that they constitute proceeds of unlawful activity? I just fail to understand that, because if I can just give an example of the matter of the National Director of Public Prosecutions and Buerta. In that particular matter, the facts were that Ms. Buerta was the head of a procurement, was an HOD and in charge of procurement. And in the process, she awarded lease contracts to a company called Trifecta, and Trifecta then leased properties to the government at inflated prices, and Trifecta then paid an amount of more than R1 million in doing renovations. Now, there is a clear connection between when the argument arose about the forfeiture of the benefits or the proceeds of unlawful activity, as the Constitutional Court found that in that matter, the renovations amounted to the proceeds of unlawful activity. It was clear. There was a contract which was awarded unlawfully, but not only just unlawfully, but there was also a benefit that was derived by Trifecta, and the benefit was also passed over to Ms. Buerta by way of renovations. So there is a connection there, but I fail to see the connection between really, I fail to see the connection between the awarding of this tender. The award. My lady will recall that case law requires that there must be a sufficient link, a sufficiently close link between the proceeds of unlawful activity and the property or the money. There must be a sufficient link between the two. So I fail to see even that sufficient link as the court had previously decided on, where even if you find that the fourth respondent had failed to disclose, even if you find that, but I fail to see that sufficient link between what the fourth respondent receives from Eskom and what it pays over to the third respondent, particularly because the amounts which the reasons why the basis upon which the amounts were paid to the third respondent on the papers is not even disputed. Yes, you may criticize the fourth respondent and say you could have done this, you could have done this, but the applicant is not disputing it on paper. It's not disputing it. So there are two problems for the applicant. The one is where is the sufficient link between those funds and their payment into the third respondent, Where is the sufficient link to suggest that they are the proceeds of unlawful activity? That's the first issue for me, and I submit they cannot be. And secondly is the issue of those are the two. And as to gratification, my lady, you'll recall that, or you'll remember that a crime of corruption, it's a crime of double intention. You receive something which is a gratification with an intention to do something. So it's a crime of double intention. Now, if it is based on PACOCA to say that the first respondent received a gratification, to do what? That's why I rest my case, unless there is a further issue that you want to raise with me. Can I just before you ask me questions, can I just find out from my colleagues if you can just give me just a minute?
Yes.
Thanks, my lady, for the indulgent. I've considered the views of my colleagues and I don't have any further submissions to make.
Thank you. Thank you. Can I propose that we take a comfort break for 15 minutes?
As the court pleases.
Thank you. Court will adjourn and convene at 3:15. Thank you. We are back.
Thank you, my lady. My lady,
Just before you start, I want to make sure that I get
everybody's
the order correct. Is everybody back? Also for the...
Yeah, we are back, my lady.
Yes, and Mr. Dow is with you. And Mr. Ramawele, are you in? Yes, you are.
Yes, I mean, yes.
All right. And I just want to make sure that I get this correct, that once you have replied, that will be the end of our proceedings, right?
That's correct, my lady.
And how much time do you need?
My lady, 10 minutes. I've got 5 points. I'll be very brief. 10 minutes might even be an exaggeration. My lady, can I ask you to go to page or take down the reference 031-299 and 031-300. That's the supplier integrity form. And my lady, you were correct when you said it's ongoing, because it specifically says at paragraph 3, it's the supplier's obligations. So Eskom suppliers accept that while they at all times, and then 3.1.1, maintain an unimpeachable standard of integrity in all their business and personal dealings, and take all reasonable measures necessary to prevent all dishonest, unfair, fraudulent, corrupt, and illegal practices during any stage of the Eskom procurement process, including the execution of contracts and contract modifications. So it's ongoing. They had that duty to disclose. My lady, they then say, we didn't raise the non-disclosure in our founding affidavit. But my lady, we only heard of the joint venture agreement in the answer. We could not have known about it beforehand. We found out for the first time there is this joint venture agreement. And because there is this joint venture agreement, we then say you should have disclosed. And we say your obligation is in terms of the supplier integrity pack to disclose. And we provide that. So to say that we had to make that case out in our founding could never have happened because we were unaware of the JV. In fact, no one was aware of the JV.
The complaint, though, is deeper than that. I mean, if you look at the way that the SIU ran this case, already the signals around a series of amendments of the relief that was sought.
Yes.
It gives an impression. Somebody's eye was not on the ball. And the question that I think the point that was being raised is that you have extraordinary powers under the Act to subpoena documents and to do all of that. And you could do that, if I have it, when you contemplate proceedings, you can approach. You could have done it after the preservation. You could have done it at any time, and you didn't do that. And I'm wondering what your explanation is, because I feel the problem is more deeper than merely. I understand, I mean, they could apply and supplement or whatever, but it seems the problem is much more deeper than this.
My lady, we say that we had asked for countervailing evidence from the various banks, but we were not able to get those countervailing evidence. So we do say that, yes, we may not, we say in our papers that we tried to get this evidence, but we couldn't. They would not provide us with the countervailing evidence. So hence...
Is that good enough, though, given your extraordinary powers to subpoena and or even to compel the provision of these documents? I mean, you were able to get a FICA directive. I know it's a different institution, but surely you should have been able to get your homework properly and done ready using the extraordinary powers that you have?
My lady, all I can do is tell you what our papers say. And we say that we tried to get countervailing information. We could not get that countervailing information. What they did or did not do is not before this court because we don't have that information. And I wouldn't want to testify from the bar and speculate as to why the extraordinary powers were not used.
Yeah, no, I'm just saying. Though,
yes,
that,
I accept it, my lady.
No, we need to, let's just take it slowly, Ms. Peth, because the point that's being raised is you say, fine, the issue about the JV came about from their answer. I accept that. But when I say the problem is much more deeper, is that there was a flurry of the amendments of the relief, one after the other. It's like this was not being looked at holistically and carefully. And then the complaint, as I understand it, is that you then change tack in terms of what your case is. That's how I understand the complaint, and that's what I need you to give me comfort with. In that once the JV was disclosed, you then change tack of the tenure of your case about probable influence in the tender and all of that, and your case shifted to that of non-disclosure.
Yes, my lady. Let me deal with that. Yes,
are we on the same page? And that's what I need you to address me on.
My lady, after our preservation order was granted, the respondents filed their answering affidavits. When we attended a case management meeting, they said that was a challenge to the preservation order and that we would be able to do our Part B separately. And at that stage, we had to do an answer to the preservation order because they were challenging the preservation order. Then later, much later, after our case management meeting, they said, sorry, our mistake. We are answering to the main relief. We are not challenging the preservation order any longer. We are now answering our main relief, and we will be prejudiced if you do not file a reply and deal with our answer as we had provided. So both parties were under the impression that they were first responding to a preservation order and challenging the preservation order, and then changed tact to say, no, we are responding to the main relief, and therefore, if you do anything else, we'll be highly prejudiced, file your reply. And which is what we then did. We filed our reply to their answering affidavits because we were all under the impression when we went to our judicial case management meeting that it was still Part A that was being challenged and not Part B.
Will you file the minutes? Because I did the minutes and ask them to be uploaded on case lines.
I will just ensure the minutes. I will make sure that it will be uploaded.
I would expect that this would have been signed by all the parties.
I thought it was already uploaded, but I apologize if it wasn't. But we will upload it, and then you can see the time frames were provided for that very reason. So, hence there was this amendments that had to take place, and not because we just didn't know what we were doing and trying to move things from one place to another. No, it was merely because now we were thinking we were doing a response to a Part A, and now we have to do a response to a Part B.
I see.
So, my lady, that is the reason why we have done it the way we have done it, and that is my only explanation that I can provide you on that issue, other than what my affidavits have stated. That is how far I can take it, my lady. My lady, on the issue of the contact with the mine, if I can give you that as case line reference, it's 009-64, paragraph 17. This is the 4th to 6th respondent's answering affidavit. And I was incorrect. They did not have a contract with Eskom prior to this one that they had. That was a contract with the mine to provide services for the mine to an Eskom power station, and not a subcontractor. So they did not have a contract with Eskom prior to the one that they were awarded. On the invoices part, my lady, just briefly there, they say we are not entitled to all the invoices, yet we are entitled to one. Now, if we are entitled to one, why not entitled to all? They can't say that because it's not very clear from the affidavit that they refer to this. Why should they give it to us? And yet they provide us with one. Why just the one? So they cannot then say, well, we can give you one, but we can't give you the others. And then your affidavit, my affidavit doesn't refer to all the other payments. Clearly that cannot be the case.
No, just let's make sure that I understood the submission correctly, is that it was, you were given what you asked for. That's the sum total of what let's visit the request.
My lady, we asked for all invoices. We did not ask for one specific invoice.
No, let's go back, because it seems, if I recall, the request seemed to have been, I'm just trying to find the,
it's
notices.
028-6.
028-6.
028-6 is our notice in terms of the Rule 3512.
028-1. This is to the first to third respondent. I'm looking for the...
It's -6, my lady.
Yes.
So we say the documents, contact, but if you go to 1.4, the bank statements, books, and invoices received from the third respondent with regards to services rendered as per the joint venture agreement, as stated on paragraphs 34, 35, and 36 of your answering affidavit. We do not ask for one specific invoice, yet we are given one specific invoice. We asked for all. So they didn't answer us
based on
what they've asked
in the affidavits.
So if we are entitled to one, why aren't we entitled to all? My lady, and then just on the submissions of the first to third respondents. My lady, they say there's no reference to the cash withdrawals. Again, I refer you to the annexures of our founding affidavit, which we said was incorporated into our affidavit. And the reference there is 010-57. And my lady, you will see that there was...
I beg your pardon, just slow down there. 010-57. 57. I'm not getting it.
Sorry, 001. Sorry, 001. I'm seeing the 1 and the 0 mixed up. 001-57. It's in the founding affidavit.
Right.
You will see 973,000 was taken out of the account, and if you go onto the next page, you will see it's a once-off payment, teller payment 2, and it's cash payments.
Let me just see where the cash payment point is. Electronic payment.
It's a teller payment. Teller payment 2. Once-off payment. Teller payment 2. Once-off payment. It was on the 4th of June. There were 2 teller payments made.
Are you on page 57?
58, my lady. The next page.
Then I need this.
It's very small.
This business.
58. The next page, right at the top, the first 2 is teller payments.
once off payment.
Yes.
All of these payments, one is Shadrach Mazibuko,
And the other one is 344 Mazibuko.
and the deposit from CLM and blah, blah, blah. And there's the
And then
one
there's the other,
paid.
yes, to Tiger Valley College and LR Extreme.
Right. So that's why you say there were cash payments of approximately 900,000.
So yes, if you take the LR Extreme and the Tiger Valley, it's about 600,000-700,000, my lady. But all in all, it was 900 and something thousand. And lastly, my lady, with regards to the seventh respondent, that we say at 001-37, that the seventh respondent was a subcontractor to Eskom. And in our response in the Rule 3512 notice, we say we could not find a contact directly with Eskom. But we say they are subcontractor. We couldn't find a contact directly with Eskom. We say they are a subcontractor of Eskom. And that has not been challenged by anyone. In fact, it's taken as proved, my lady, because the seventh respondent hasn't said anything to counter that fact. So they are a subcontractor of Eskom as well. My lady, that is our submissions.
Yes, thank you. That is the end. Yes.
My lady, just as a matter of clarity, just on the last issue that we were debating about the cash withdrawals, may I just clarify it, because it appears as fact here the document that there were no cash withdrawals on page 57.
Just 1 minute. I was ready to close.
Yeah, I understand, my lady, but it's a very important aspect.
Just one moment. Give me a time to go back.
00157.
I first need to go back to your case. As I say, I was ready to. I am hoping that you don't get an impression that by hearing you out, I'm entertaining a reopening of debates.
No, just clarity, my lady.
I just need that to be clear.
Yes,
all right. Okay, so you want me to go back to 010-57?
001-57, yes. The bank statement. The second column on page 57, my lady.
I'm on page 57, yes.
There is a second column there which says funds used debits.
Where are you?
The second column.
Funds used debits.
And then
right?
it says cash withdrawals branch, cash withdrawals other, and it says 00. And my lady, we are saying that it might be another interpretation of once-off payments, but doesn't necessarily mean to a cash withdrawals. So in respect of this very same statement, they say there were no cash withdrawals.
All right, so what is the on the next page, 4th of June, teller payment to?
It's an electronic payment, money.
Why do you say that?
Money, that's
teller payment, as I understand it, is you go in person inside the bank and you get you withdraw from inside the bank. and you walk out with cash from inside the bank, and it's not an inter-account transfer or an EFT. That's what I understand about teller payment too.
Yes, but my lady, it is what it is, my lady, because if otherwise the statement itself is self-defeating when it says there were no cash withdrawals, and on the other hand, it speaks to the once-off payment.
Payments.
Yes, we are saying those teller payments are electronic payments. That's what we want to. Electronic payments. Electronic payments. They are not cash withdrawals. Because on the statement itself, it says there were no cash withdrawals. So I guess when you have a statement like this, it is best that the banker must be able to explain it, because I am saying it means there were no zero cash payments, and my colleague says there were cash withdrawals.
I think that the importance would be to pay into, if we're talking here, I mean, it tells you who the payments were being made to or whatever. It's here. Yeah. Teller payment to Mazibuko, the teller payment to that party, the teller payment to that party. All right. So it was not an inter-account transfer or EFT. It's
yes. That's what I just had to point out to you.
I can't see how after this teller payment one walks away with anything other than cash.
But Manini, then the statement must speak for itself and clarify, because on the other hand says
there's once-off payment to so and so.
Yes.
Once-off payment to so and so.
Yeah. So that's our submission, that Manini, then the bank account is confusing, and my instructions were there were never cash withdrawals.
Right.
Yeah. And it's about withdrawals and not payments, money.
Right. Thank you.
Yeah. As a court, please.
Yes. Is that the end of our business today? Wonderful. I want to thank all of you for assisting me to complete this matter within the day. And just to let you know, I'm going to take some time. So judgment is reserved. And when judgment is ready, you will be notified. And thank you for your assistance. The court is adjourned.
As the court says, thank you.
Thank you.